Bless your Lordship. I pick to mention item number 3, Your Lordship. I pray that the matter may become after a week.
Item number 3.
Yes, Lordship.
What do you want here?
Yes, Lordship.
Your prayer?
I'm for the applicant. I pray that the matter may become after a week.
After a week.
Yes, Lordship.
Okay. Anyone appearing on behalf of the respondent? Anyone from the
Yes, ma'am.
who is for the
On behalf of additional advocate.
You're for the respondent.
Yes.
How many respondents are there in this case? You are appearing on behalf of the respondent number?
The sole respondent.
Or sole respondent?
Yes.
Okay.
There's only one.
So you have no objection?
Your Lordship, this matter is under cabinet approval. So if we could make it 4 weeks, we list it after 4 weeks, Your Lordship.
4 weeks?
4 weeks, that will be very long, Your Honor. It's pending since 2020, this petition. So I pray that 2 weeks soon.
2 weeks.
Yes.
Okay. Line of counsel for the petitioner, Mr. You are
Gauhati.
Supponte prays for 2 weeks times, to which the line of counsel for the sole respondent has no objection. So put out this matter after 2 weeks. Okay.
Obliged.
May it please your Lordship,
Yes.
a bail application number 23 has been filed yesterday, and I want it to be listed today because of some medical contingencies that are like hovering around the applicant.
Bail application
Yes, so may it kindly be listed today.
on 439,
Under 439, my Lord, yes.
not tomorrow.
In fact, I have a part-heard matter at Dimapur District Sessions Court, my Lord. Because of that, I request you to kindly hear me today. In fact, the bail application was supposed to have been filed a long time back, but because of this Durga Puja long holidays, it could not be filed on time also.
Okay.
So kindly allow me to be listed today. It has been filed yesterday, my Lord.
Okay.
Much obliged.
Okay, sorry. I'm back to mention item number 14, 1-4. If this might be listed next week, I have taken the consent of the advocate for the petition. Appellant.
When do you want?
Next week, Lordship.
Line counsel for the petitioner, Mr.
Yamarwati.
Prays for adjournment
For 1
of
week.
the matter,
For 1 week.
Okay, for 1 week. He has a consent from the other side.
He is in court number 1, Lordship. I have taken
Okay,
his consent.
there's a consent from the other side.
14.
Stop. The prayer is allowed. Put up this matter next week. Okay.
What's what?
Yeah, please, my lord. Lordship, item number 16, 16.
Yes,
May it be listed after 2 weeks. We have taken the consent of the other parties. Therefore, I'm for state.
okay. You are for a petitioner,
No, for state respondent.
state respondent,
Lordship.
sorry. You are for the petitioner.
Yes, sir.
You have no objection.
No, Lordship.
Okay. Learned advocate, Mr.
Yeah, and then my lordship.
Okay, government advocate, Mr. So-and-so. Prays for
2 weeks. 2 weeks.
adjournment of the matter, sorry, prays for listing the matter after 2 weeks, to which the learned counsel for the petitioner has no objection. Stop. List this matter after 2 weeks. Okay.
Bless you, lordship.
May I please, Your Lordship? I beg to mention item
Yes.
number 18.
18,
On behalf of my senior Easy Mommy,
okay.
Your Lordship is currently out of station, so kindly list the matter after 2 weeks.
You are for the petitioner,
Yes.
and who is for the other side? State,
No objection.
no objection, okay. Learned advocate, Miss
And solo,
Solo, appearing on behalf of this, your name is also there in the cause list?
no, Your Lordship.
Okay. Appearing on behalf of Mr.
Easy Mommy,
Elise Zimomi, Learned Counsel for the petitioner, prays for adjournment of the matter for 2 weeks, to which the Learned Counsel state, Learned Government Advocate has no objection. Stop. Prayer allowed. Case adjourned.
Your Lordship, there's an interim.
Okay. List this matter after 2 weeks. Stop. In the meantime, the interim order passed earlier shall continue.
May I please the Lordship?
Yes.
Lordship, I beg to mention item number 8, Lordship. I'm for the state respondent.
Item 8.
Item 8, Lordship.
Yes.
Lordship, here I'm yet to receive instruction, Lordship. So, Lordship, please.
You are for
For the state respondent,
state.
1, 2, and 3.
Lordship, it's a covered case and as much as possible, it needs immediate disposal of the
Okay.
case.
Okay. You are praying for how
3
much
weeks time, Lordship. Since
Three.
I'm yet to receive instruction,
instruction?
Lordship.
So you have not yet filed written objection.
No, Lordship.
Affidavit, no,
Since
not
I
yet.
have not received any instruction from the state respondent, Lordship, I'm
Hmm.
unable to file my affidavit.
So it is in
So,
admission.
Lordship, please to grant 3 weeks time.
You are government advocate.
Lordship.
Okay. Mr. So-and-so, then government advocate. Submits that he is yet to receive an instruction from the state respondent
Lordship.
to file affidavit in opposition
Lordship.
and prays for three,
Three
prays
weeks time.
for 3 more weeks
Lord.
for filing affidavit in opposition. Stop. Learned counsel for the petitioner, Miss.
Zed Jimomi, Lordship.
Okay, he is also present. And has no objection. To the grant of 3 week times. Sorry, to the grant of time to the Learned Counsel for the respondent. However, she submits that since the matter is
It's
a
a covered case.
covered
Yes,
cases, the state respondent may be, state respondent may be asked to ensure to file the affidavit by the next date.
Lordship.
Okay, put up, list this matter after 3 weeks. Okay,
Oh,
in the
Lordship.
meantime, the state shall file affidavit in opposition. Okay. State shall obtain necessary instruction and file affidavit in opposition. Okay,
Hello.
Oh,
yes,
May it please your lordship,
yes.
I beg to mention item number 4. If your
Item-
lordship may kindly fix this matter after 2
Item
weeks.
4,
Yes, your lordship.
you are for You are- respondent,
Yes, your lordship.
respondent number,
Uh, 3, your lordship.
you are for 3.
Yes, your lordship.
How many respondents are there?
There are in total 3 respondents. your lordship.
Okay,
I'm for the appellant.
you are for the appellant.
Yes.
You have any objection?
No, no lordship.
Okay. But Learned Counsel for the respondent, what for
I'm
you
sending
want?
on
3
behalf of
weeks?
my senior.
Hmm?
I'm sending on behalf of my senior Joshua Shiki.
Oh, you are appearing on behalf of the senior.
Yes, your lordship.
Who is your senior?
Joshua Shiki.
Hmm?
Joshua Shiki, your lordship.
Just Learned advocate. Mr. His name, huh? Appearing on behalf of his senior, Mr. Joshua.
Your lordship, we have filed our affidavit.
Hmm?
We have filed our affidavit. I mean, recently last week, but they will be filing affidavit in reply.
You have already filed your affidavit.
Yes, your lordship.
The objection they have filed. We, in respect to my IA,
Okay,
IA 139 of
Hmm.
2022.
appearing on behalf of his senior so prays for
2 weeks time.
2 weeks' time. To which the learned counsel for the appellant has no objection.
Lordship.
List this matter after 2 weeks.
Bless you, lordship.
Yes,
My please, Lordship.
yes,
Lordship, I beg to mention item number 17.
17.
Yes, my lord. I'm appearing on behalf of respondent number 3. Lordship, kindly grant me 2 weeks time to file my affidavit in opposition.
You are for,
Respondent number 3, my lord.
respondent number 3.
Yes, my lord. I'm here to file my
Who is for the appellant?
applicant, Sir Limo.
He is not present.
I've taken his consent.
You have taken his consent.
Yes, Lordship.
Yes,
For the petitioner.
okay, he is praying for
2 weeks time.
2 weeks. You have
No
any
objection.
objection? No
No
objection.
objection.
Okay. Learned counsel for, learned advocate, Mr.
Manik, my lord.
Manik Konya,
Yes, ma'am.
for the respondent number 3, prays for 2 weeks' time. For what?
To
You
file my counter
file?
affidavit in opposition.
Okay. Okay, seek for 2 more weeks to file affidavit in opposition. To which the learned counsel for the appellant has no objection. Stop. In view of the above, the prayer is granted. Stop. List this matter after 2 weeks.
Lordship.
Okay.
Lordship, I'd like to mention item number 15, Lordship.
Yes.
I'm mentioning on behalf of my senior, Mr. Timo Pang.
Hmm.
15. Lordship, my senior is
You are for? You are for petitioner or
petitioner,
revision petition? Petitioner.
15.
You are seeking for how much time?
Already mentioned things.
I've already mentioned.
Hmm?
14.
Already mentioned.
14.
It's 15.
14.
Item 15.
15, yes, 15.
15 not yet mentioned, I think,
Lordship, and 15 after a week, Lordship.
after a week.
After a week, Lordship.
After a week. Okay. Then advocate, Mr.
For Seco, mentioning on behalf of my senior, Mr. P. Limao,
Seko, appearing on behalf of
my
his
senior, Mr.
his
Limao.
senior, Mr. Lema Wangpang, Wapang, land counsel for the revision petitioner, prays for 1 week.
A week, Lordship.
Okay, 1 week time. To which the land counsel for the respondent,
Stop.
Mr.
Yamawati.
Okay, has no objection. Stop. He is prayed for, this list is matter after 1 week.
Lordship.
Okay.
Bless you.
May I please, Lordship? By oversight, Lordship, I have mentioned item number 14. I was supposed to mention item number 15, but I have mentioned 14.
Oh,
So this.
this
order might be-
14 was a 15.
I should have been mentioning 15, but
15.
instead of that, I have mentioned 14. My mistake, Lordship. So this.
So the
that-
order in
That
14,
will be recalled, Lordship, and this
Okay.
matter can be taken up.
then, okay, then,
Item 14 will be recalled.
okay, 14, leave 14, huh? Okay. Okay. Yes. Yes.
For motion, item number 1.
May I please, Lordship?
Yes, please.
Lordship, I'm appearing on behalf of IH Sakya, the leading counsel for the petition. Lordship, the counsel is out of station, so can you let the matter come after 2 weeks now?
Okay. Learned advocate, your name? Good.
Mani Kunjaman.
Appearing on behalf of
I ate cycling.
the senior. Mr. Ayet Saikia, Land Counsel for the appellant. Submits that the senior, Mr. I.H. Saikia is out of station and prays for
2 weeks time.
2 weeks' time. Stop. Then your government advocate.
None.
Oh, so PP. Mr. Learned PP Nagaland is also is present and has no objection. Stop. List is made after
2 weeks.
2 weeks. For motion. Okay.
For admission, item number 2.
Yeah, please, Lordship.
Yes, please.
This writ petition has been filed for non-payment of pending contract bills, madam. The petitioner hearing was awarded the work for construction of approach road connecting government higher secondary school to Chubukidima. That is at page number 11, annexure A, madam, the work order. Page number 11, annexure A. So Lordship got it.
Of the
Writ petition, madam. Page 11, annexure A. This is the work order dated 10 April 2015. Work order for construction of approach road connecting government high schools, higher secondary school to Chubukidima, package 1. The petitioner was awarded to work in 5 packages. Annexure B is package 2, Annexure C is the package 3, Annexure D is package 4, and Annexure
A
is package 1.
package 1.
The next page 12 is package 2.
B.
Yes, the next page, page number 12.
Okay.
And then the next page number 13 is package 3. Same, my lord. And page number 14, the next page is package 4. And page number 15, annexure E is package 5. The total amount is 18,70,250. In terms of this work order, my lord, the petitioner has completed the work within the given time, my lord. As per the work order, the work was.
What was the work?
The work is, my lord, annexure A, I may be allowed to read.
Please.
To MS Zilzi government registered class 1 contractor and supplier and with number 03, Kohima, Nagaland. Subject is work order for construction of approach road connecting government higher secondary school to Chubukidima, package 1. Dear sir, with reference to the tender dated number dated 4th April 2015, I am to issue the work order for construction of approach road connecting government higher secondary school to Chubukidima, package 1. At the rate of 30% above NPWD's schedule of rate 2010, amount will be 3,55,260. Only under the following terms and conditions. Number 1, work order amount is as per percentage rate quoted by you in annexure A. This is fixed for the period of construction of the project. Number 2, no escalation of rate, whatever so may be, the ground will be allowed. Number 3, all works must be completed within 6 months from the date of issue of this order. 4, if the project is not completed within 6 months, penalty will be charged as per rule contract agreement. Number 5, all the materials brought to site must be physically approved by the executive engineer, assistant engineer of this division before use in the said construction. Number 6, works tax will be deducted out of the contract amount and will be done as per the prevailing terms of the government, state government. Number 7, all the proportion of materials used in this work must be approved by the executive engineer, assistant engineer, junior engineer of this division. Otherwise, the same quantity cannot be recorded for payment. Please attend this office within 15 days from the date of issue of this work order to sign the agreement form 2 before commencement of the work. This is the work order of package 1. As per this, the petitioner was to complete the work within 6 months. The next page is package 2.
Similar.
Only the amount is different.
Hmm.
So he was given 5 packages to do a total amounting of 18,70,250. In terms of this work order, the petitioner has completed the work within the given period of time. Now, after completion of the work, since no payment was made to the petitioner, even after the completion of the work, the petitioner have submitted a legal notice on 25th of March 2019. That is at page number 16, Annex F. That is the legal notice, madam.
Yes.
So the petitioner has given a legal notice to the Director, Municipal Affairs and Executive Engineer for payment of the pending contract bills. However, in response to the legal notice, the respondents have replied that in view of non-availability of fund, payment could not be made. And then the reply is at page number 20, my lord. Page number 20, Annex H. The operative portion is at page number 21, my lord, the reply.
What is this page number 18?
Page number 18 and page number 20 is the same annexes, my lord. I have made enclosures, the same 2 enclosures.
Oh. This is the same reply.
Yes, yes.
Okay.
So I'm referring to page number 20.
Okay.
18 and 20 is the same, madam. Mary, madam.
Yes.
This is the reply to the legal notice. To Yalamson Advocate Gauhati High Court, reply to legal notice. Sir, the Department of Municipal Affairs has perused your legal notice dated 25/3/2019 for release of the contract bills amounting to rupees 18,70,250. The Ministry of Urban Development, Government of India, has sanctioned the project integrated development of Jumbukittima Town Roads under the scheme UDISSMT transaction phase of GNRUM by Ministry letter number so and so. Data so and so amounting to rupees 1946.43 lakhs. The department was directed by the then Honorable Secretary Urban Development to include the work executed to Wanshi Pele, prefect's accompanying work from Government High School Jumbukittima to Town Baptist Church under the said project. Accordingly, the department forwarded the matter to the government seeking administrative approval for inclusion of the said work in the project. Hence, the work order was issued to MS Zilid and PWD number 3, that's the petitioner, amounting to rupees so and so, with the condition that payment shall be made subject to availability of fund. That as per the Ministry Office memorandum letter, white letter number so and so dated 4/8/2015, funds for all the projects approved under UIDSSMT could not be released as on 31/3/2014. Hence, the projects were dropped and funding could not be considered. This is the reason they have given. Next, that the department initiated a proposal for additional plan allocation under state plan by letter number so and so dated 29/6/2017 to the state government, but no sanction was accorded till date. It is regretted to inform you that due to non-availability of fund, payment could not be made to the contractor for the completed work till date, as there is no budgetary allocation under demand number 37 Municipal Affairs for the said work. This is for your necessary information. They have said that there is no fund. And the next page is the letter which they have referred to. Annex I, page number 22.
The letter?
Letter dated 29 June 2017.
Okay.
Annex I, 22, page number. Here is my lord, Governor Nagaland, Director of Municipal Affairs. Do the Commissioner and Secretary Department of
This
Municipal
letter was written by?
the additional Director and HOD.
Okay, to?
The Commissioner and Secretary to the Government, Department of, for seeking for additional allocation of fund.
Okay.
May I read my lord?
Yes.
To the Commissioner Secretary, Department of Municipal Affairs, Nagaland, Kohima. Subject is proposal for additional planned fund allocation for the work construction of approach road connecting Government Higher Secondary School to Jumbukittima. This is regarding the work order given to the petitioner. Sir, with reference to the subject cited above, I have the honor to state that the Ministry of Urban Development, Government of India has sanctioned the project integrated development of Jumbukittima town roads under the scheme UIDSSMT amounting to rupees so and so. The department was directed to include the work, preface company work from Government High School, Jumbukittima to Town Baptist Church, and contractor has completed the work. So there's no issue that I have not completed the work.
It is so admitted. Admittedly, okay.
Yes, it is admitted that I have completed the work.
Hmm.
However, as per the Ministry's Office Memorandum White Letter number so and so dated 4th August 2015, all projects approved under UIDSS-MT where funds could not be released as on 31st March 2014 stood dropped and would not be considered for funding. As such, payments could not release to the said contractor for the completed work till date, as there is no budgetary allocation under demand number so and so municipal affairs for the said work. It is therefore requested to kindly take up the matter with planning and coordination department for releasing the required amount under non-plan as additional during 2017 to 18 to make payment to the contractor to avoid litigation. So there is no dispute that I have not completed the work, but only the reason stated by them is that the funding has been dropped and there is no fund. So I could not be paid the contract bills. The state respondent, by filing the counter affidavit, they are contending that since the work awarded to the petitioner was under a centrally sponsored scheme.
Just a
and-
minute, just a minute.
Yes, ma'am.
So, the work order was issued in the month of April 2015.
Yes, madam. And now it is.
And then but the work, construction of this was dropped when it was dropped.
2014.
So how it is? You have constructed after dropping of the project.
I was given the work order on 10th April 2015 as per the work order.
After dropping the project.
I'm not aware, as per this work order, there's no mention that the work is under CC scheme or under any, no mention is there, madam. I was given this work order. As per this work order, I have completed the work. Only after the completion of the work, when I started claiming for my pending bills, they have stated that this was under a CC scheme and then the funding has been stopped, and in view of non-ability of fund, my payment could not be made. That is the excuse they are making.
So this work order was given by the executive engineer.
Yes, municipal affairs. That is the whole condition. State
He
respondents.
is supposed to know that the project was dropped.
Yes, madam.
It was not informed to you.
No, as per the work also, there's no mention. No
Okay.
mention.
Okay, then.
Now that after only I started claiming for my bills,
Hmm.
they've come with an excuse that,
After execution of the work.
yes, after execution of the work.
Yes.
They're saying like funding has been dropped since
Hmm.
it wasn't under CC's central sponsor scheme. My payment could not be, and then we have sought
And then the
for
reply,
additional
the reply was given by whom?
by the
Reply that saying that. the
deputy
funding-
director.
Okay, deputy director.
Yes, HOD.
No, the reply also executive engineer, it appears.
Reply to the legal notice.
Hmm,
It was given by the deputy director,
deputy director.
director of municipal affairs.
No. This page 19, executive engineer.
Yes, yes,
This is a reply to legal notice dated 25. This is same, I think, but then executive engineer
yes.
or executive engineer is he is for directorate of municipal, okay. The same person has given this reply to you.
The reply was given by the direct, yes, by two persons with us. Yes, same, on the same ground,
On the same.
stating the same ground. Just a copy paste. Only the issuing authority was, because I've addressed my legal notice to the director as well as to the executive engineer.
Okay, so.
So they have accordingly replied, just the same contains only the address.
Okay,
was
okay,
different.
then,
Then they have enclosed the annexure I, page number 22, stating that funding has been stopped and in view of which I could not be paid for the completed work, and they have sought for additional fund to the government.
okay,
But till now, no update, and then I've not been paid. So in view of that, I've approached the honorable court seeking for a direction to release my pending bills. The state respondents, by filing the state counter affidavit, they're contending that since the work was under a centrally sponsored scheme and the funding has been stopped, I could not be considered for, my payment could not be made. And then whereas on the other hand, the ministry, the Union of India, they have filed the affidavit stating that the state respondents.
State is present.
Yes. State.
Okay, yes, so
They are shifting the burden upon each other. They are saying that it is the center that who is liable to pay. And whereas on the other hand, the Union of India, they are shifting the burden to the state, saying that knowing that the funding was also to drop, they have issued the work order to me.
Union is also appearing.
Yes.
Okay. Yes, who is the main respondent here? You're claiming against the state?
Yes. State.
Okay.
And the state is shifting the burden to the union. It's a whole issue.
Shall I submit?
Yeah, please.
We are not shifting the burden to the union, Your Lordship, but we are with proper documents showing that the project actually is sanctioned by the central government, not by the state. The project belongs to the central government. We are just the one who is implementing the project, Your Lordship.
Okay.
Lordship, my learned friend have already shown the work order,
Yes,
but Your Lordship, allow me to go to the work order again, Your Lordship.
please.
Because Your Lordship, my learned friend has not pointed out the place where the work was supposed to be executed.
Okay.
And this is important, Your Lordship. The 5 work order that is annexed as Annexure A to Annexure E, starting from page 11 to page 15, all relates to construction of an approach road at Sumokedima. 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 Your Lordship, at subject.
Sumokedima.
Yes, at subject, if you see, this is work order for constructions of the approach road connecting Government Higher Secondary School to Sumokedima. This is package 1. Your Lordship, page 12.
Yes,
Page 12, Your Lordship.
yes, please.
Again, same thing. Work order for constructions of approach road connecting Government High Secondary School to Sumokedima, package 2. Page 13, same thing, except that it is package 3. Page 14 and 15 also, Your Lordship, if you see, it is the same thing, except that it is package 4 and package 5.
Yes,
So the place where the work was supposed to be executed is at Sumokedima, Your Lordship. Now, why I'm mentioning this is because, Your Lordship, this is important for the fact that this is the work that was sanctioned by the central government, given to the state to implement it. Your Lordship. What happened is this, Your Lordship. By an office memorandum dated 4/3/2014, which is annexed as Annexure A, page 6 of my affidavit in opposition, Your Lordship. Affidavit in opposition on behalf of respondent 1, 2, 3, and 4.
yes,
Page 6,
yes,
Annexure A. Now, this is an office memorandum, Your Lordship. The type copy, Your Lordship will find it at page 8.
yes,
I may be allowed to read from the type copy, Your Lordship.
please.
The subject is released, Your Lordship. Release of additional assistance, additional central assistance, ACA, to Nagaland for urban infrastructures development under UIDSSMT scheme during 2013 and 14. Subject also, it's very clear, Your Lordship. It clearly says release of additional central assistance to Nagaland for urban infrastructures development under UIDSSMT. Now, Your Lordship, UIDSSMT means Urban Infrastructures Development for Small and Medium Town Scheme.
Okay.
Now, Your Lordship, by this office memorandum, the central government has agreed to release an additional fund. Now, Your Lordship, if you see at para 3 of the same page, para 3, it starts with as per the decision of the cabinet. If I may be allowed to read this, Your Lordship.
Yes.
As per the decisions of the Cabinet Committee of Economic Affairs on 17/1/2013. The following project may be considered for release of first installment of ACA. Now, Your Lordship, ACA, as I've already read it out, it says additional central assistance. Now, Your Lordship, what was the project approved? Well, Your Lordship will find it on the next page.
Yes.
The details of the projects are given under. We are concerned with serial number 2, Your Lordship,
Okay.
Sumogedima. Name of the town, Sumogedima. Project component, road. MOUD, SSLP approved cost, this much. Eligible criteria, and Your Lordship will find the last column, first installment, 875.89. There was also another project under the Dimapur Ward number 4, where the first installment stands at 222.83. That is the first one, Your Lordship. But we are not concerned with that. We are concerned with project number 2, Sumogedima. Now, Your Lordship, para 6.
Yes.
If I may be allowed to read this again, Your Lordship.
Yes.
In view of the above, Department of Expenditure, Ministry of Finance is requested to release 1098.72 lakhs as first installment to SLNA of Nagaland. That is the Directorate of Urban Development, Government of Nagaland under UID SSMT during 2014 and 19. Now, Your Lordship, if you refer to para 5, Your Lordship, it clearly says that the state government of Nagaland has designated the Department of Urban Development, Government of Nagaland, as the state level nodal agency for implementing the UID SSMT scheme.
Okay.
And the next para says, Department of Expenditure, Ministry of Finance is requested to release 1098.72 lakhs as first installment
Where do we find that?
para 6, Your Lordship,
Okay.
to SLNA, that is the state level nodal agency, which is the urban development in the state of Nagaland. Now, Your Lordship, how did the figure 1098.72 comes? As mentioned in the para 6. It is the total amount of the 2 projects that was sanctioned to the state government under this office memorandum. Your Lordship may kindly refer the top column again, the details of the project.
Yes.
If you see the last column, the first installment, it is mentioned. Total amount, 1098.72.
Yes.
Now, Your Lordship, it is because of this office memorandum, and it is under this office memorandum, this urban development, Department of the Urban Development, Government of Nagaland has been made as the state level nodal agency for implementing the project. Now, since the department has made us the nodal agency to implement the project, we have, by implementing the project, issued the work order to the petitioner. Now, if you see, Your Lordship, the work order was issued on 10th of April 2015. Your Lordship, as I've already shown the work order at page 11. The work orders were issued on 10th of April 2015.
Yes.
Lordship.
Yes.
Then what happened, Your Lordship? After we have issued the work order to the petitioner, stating that the work should be completed within a period of 6 months. Your Lordship, if you see the work order, at condition number 3.
Yes.
The work order was issued with certain terms and conditions, but Your Lordship, I will read the condition number 3 in the work order. It says, may I read my note?
Yes, please.
All work must be completed within 6 months from the date of the issue of this order. That means the effective date is 10 April 2015 and 6 months after,
Yes.
within 6 months period, the contractor, who is the petitioner herein, will have to complete the works. Now, after all the work order has been issued to the petitioner as per this office memorandum, and as per the assurance given to the state government by the central government, Your Lordship, the central government has brought out another office memorandum.
Yes.
Your Lordship will find that office memorandum, the second office memorandum dated 14th of August 2015 at page 10 of my affidavit in opposition, Annexure B.
Yes.
Your Lordship, the type copy, Your Lordship will find it at page 18.
Yes.
Page 18, Your Lordship. Subject: detailed instructions regarding coverage of incomplete project, Your Lordship, of earlier mission in pursuance of para 17(1) of the guidelines of the Atal missions for regenerations and urban transformation. Now here, Your Lordship, by this notification at para 10, Your Lordship, page 20. Para 10, page 20. Lordship, para 6, I beg Your Lordship apology. Para 6, page 20.
Yes.
This is with regards to other issues. Para 6.
Yes.
6B, Your Lordship, we are concerned with 6B on the next page. Other issues, 6B.
Yes.
Now here it says, all projects which were approved but fund could not be released as on 31st March 2014 stand dropped and will not be considered for funding. Your Lordship, the first office memorandum, when did they issue? 4th of March 2014. The first office memorandum, they issued it on 4th of March, asking us to implement the project, even informing us the amount of 1098 crores will be released to us as the first installment. We are asked to implement the project. We started implementing the project by issuing the work orders to the petitioners as well as to the other contractors. Then all of a sudden, Your Lordship, in the year 2015, they came up with this office memorandum by an office memorandum 14th August 2015. They say that the project which could not be funded or released as on 31st of March 2014 stands dropped and shall not be considered for funding. By 4th of March 2014, they asked us to implement the project. They say that they are releasing 1098 crores of rupees to us.
So it was not released.
It was never released.
Never released.
Never released. Instead of releasing the amount, they came up with this office memorandum, 14 August 2015, and they say that the fund stands dropped. And that also the date, if you see the date, Your Lordship, look at the date that they have mentioned. It says 31st of March 2014. The project which was approved but fund could not be released as on 31st March 2014 stands dropped and will not be considered for funding.
Yes.
Now, Your Lordship, this particular office memorandum 14th August 2014, 2015, Your Lordship. 14th August 2014, informing that the project, informing that the fund would not be released and the project stands dropped, was informed to the state only after we issue the work order and only after the petitioner has completed the work. Your Lordship, the petitioner in his affidavit in opposition, affidavit in reply, has admitted to the fact that he has completed the work before the issuance of this office memorandum, 14 August 2015. If Your Lordship will may allow me to take my Lordship to the affidavit in reply filed by the petitioner against the affidavit in opposition of the state respondents.
Yes.
Para 4, page 3.
Affidavit in reply.
Affidavit in reply of the petitioner against the affidavit in opposition filed by the state.
Yes. Para.
Para 4, page 3. May I read, Your Lordship?
Yes.
That with regard to the statement made in para 6 and 7 of the affidavit in opposition, this deponent begged to state that nowhere in the work order it is mentioned that the work executed by the petitioner is under UID SSMT scheme or other centralized process scheme funded by the ministry. It is an admitted fact that the petitioner has completed the works awarded to him within the stipulated time and to the satisfactions of the authorities. Whether the works executed by the petitioner is a state funded or funded by the central is not the outlooks of the petitioner. The petitioner have already completed the work and it is the duty and responsibilities of the respondent authorities to make arrangement or to approach the appropriate authorities for release of the petitioner's pending bills. The petitioner is not concerned whether the work executed by the petitioner was funded by the ministry, which was subsequently dropped. The only concern of the petitioner is that he should not be deprived of his legitimate rights for payment of the pending bills for the work already executed by the petitioner. Now, Your Lordship, the next line is important. The petitioner was awarded the work on 10/4/2015. Here there is a mistake, Your Lordship. The petitioner actually was awarded the work on 10/4/2015, not 8. And the office memorandum, Your Lordship, and the office memorandum by which the funding was dropped was issued on 14/8/2015. And also completed the work prior to the issuance of the said OM. Therefore, the work order and the execution of the work being issued and completed prior to the OM dated 14/8/2015, it is the duty and responsibilities of the respondent authorities to make necessary arrangement for clearing all the pending bills to the petitioner, and the petitioner should not be made to suffer for no fault or lapses on his part.
Yes.
So the petitioner also have completed the work because he was allotted a 6 months period to complete the work, and he has completed the work. But to make payment to him, we are supposed to receive the fund from the central government. As shown by me to my lord that the project belongs to the central government. It is not a state project. We have not initiated the project. The central has allotted us and given us the assurance that the amount of 1098 will be released to us as a first installment and have asked us to implement the project. We did that by issuing the work order. In the meantime, Your Lordship, they brought up this new office memorandum stating that all the projects which was earlier approved, but fund could not be released, stands dropped and will not be considered for funding again. Now, as stated by me, Your Lordship, in my affidavit in opposition, The central government is actually like a mother abandoning the child. They have asked us to do it. We did it. Now they come up with a new office memorandum stating that no, whatever we have asked you to do it, we don't know. But we are not releasing the amount. We are not funding you anymore. We have been put in such a situation, Your Lordship. Now, Your Lordship, as far as the funding, with regards to the funding, as to whether the funding is a state project or a central project. Your Lordship, the central government, Union of India, in its affidavit in opposition, has clearly stated that it is a union project.
Okay.
Your Lordship, affidavit in opposition filed by the...
So there was no any contribution from the state? State doesn't have to contribute anything in
State share is just...
in the funding.
Yes, state share is just the 10% of the project.
Okay, where do we find that?
Your Lordship will find it Your Lordship, the release of fund, page 19. 19 of my affidavit in opposition.
Yes.
Para 3, release of funds. Release of funds, Your Lordship.
Yes.
The last column, cities, towns, US in northeastern states and Jammu and Kashmir. Central share, the next column, Your Lordship. Central share for ongoing project, 90%. Now, Your Lordship, to this effect, Your Lordship, I have, on the earlier occasion, I have already submitted a letter issued by the Undersecretary to the Government of Nagaland, Department of Municipal Affairs, to the Secretary, Ministry of Urban Development. Your Lordship, I have placed this particular letter on the last occasion, Your Lordship. Here also, the state government have admitted that
what is that?
The letter dated 7th October 2015, issued by the Undersecretary to the Government of Nagaland,
Yes.
to the Secretary to the Government of India, Ministry of Urban Development. Letter dated 7th October 2015.
Yes.
Your Lordship, if you see on the first para, sir, subject is integrated development of Chumakidima Road project under UIDSSMT scheme, JN Nuram.
Yes.
Sir, I'll just read the first para, Your Lordship. Sir, I'm directed to refer to the Additional Director and HOD, Municipal Affairs Department, Government of Nagaland, letter number such and such, on the subject cited above, and to inform you that the Government of India has sanctioned the said project under the scheme UIDSSMT, transition phase of JN Nuram, via ministry letter, that number such and such, amounting to 1946.89 lakhs, with central share of 1751.79 lakhs, and a state share of 194.63 lakhs. Your Lordship, the state share of 194.63 lakhs, this is the 10% of the amount, total amount, 1946.89 lakhs, Your Lordship.
Which one? The figure? 19?
The state share of 194.63 lakhs, as stated in this letter.
194?
Yes, 0.63 lakhs, the state share.
Where do we find?
Your Lordship, in the same para, last line,
Okay,
with central share of
the central.
1751.79 lakhs and the state share of rupees 194.63 lakhs.
Okay, okay. This is
Now,
not-
194.63 lakhs, Your Lordship.
Hmm.
This is the 10% of the total amount of 19,194.689 lakhs.
Yes.
So the state has got only 10% share.
Hmm. Yes.
And therefore, Your Lordship, it is evidently clear that the project belongs to the central government. The central government asks us to implement the project. We have, by implementing the project, we have issued the work order. And then by an office memorandum 14 August 2015, the central government came up with the decisions that the project is stopped, the funding is stopped, and all the project which was approved earlier stands dropped. These are the reasons why we could not make the payment to the petitioner, Your Lordship. Now, if the central government releases the fund, Your Lordship, as and when the central government releases the fund, we are ready to make the necessary payment to the petitioner as his pending bills, Your Lordship.
Okay. Yes, sir. Sir, central government.
To make it very brief, project, I'll just read out 3 paragraphs from my affidavit in opposition. My
Yes.
affidavit in opposition.
Affidavit.
Affidavit in opposition of respondent number 5. My lordship may
Yes.
come to.
Yes, yes.
My lordship may come to page number 2, para 3. I'll read
Okay.
Para 3, 4, and 5.
Hmm.
Para 3, lordship. That it is further stated that the Jawaharlal Nehru National Urban Renewal Mission was implemented by the government of India with effect from, that is very important, lordship, 3/12/2005 up to 31/3/2012. That is for 7 years, beginning from 2005 to 06. The JNNURM was extended from 1/4/2012 to 31/3/2014 and was called transition phase of the JNURM. 4, that it is further stated that the Ministry of Finance did not release the fund for the instant project along with some other projects. The project therefore stood dropped for funding by central government from 1st April 2014, lordship. 1st April, drop the funding by central government from 1 April 2014. The state government was well aware that the fund has not been released for the said post project, and the transition period has also ended on 31/3/2014. The said project. Next question, lordship. The said project was therefore not at all eligible for funding by the government of India. In spite of this, the state government has issued the work order in 5 packages, dated 10/4/2015, with a total cost of rupees 18.70 lakhs only of the said road project. Almost 1 year after the end of the transition phase, without any consultation of the Ministry of Housing and Urban Affairs. Then, lordship, para 8.
Yes.
That with regard to the statement made in the paragraph 8 of the petition, the answering deponent states that the Ministry of Housing and Urban Affairs has no role in the payment of bill, as the project was conceptualized, approved, and work order was awarded by the state government itself. So without consultation with the central government, the work order was issued. Then, in fact, Lordship, the project JNNURM expired in the year 2012. However, it was extended till 1/4/2012 to 31/4/2014. So, and after the project was dropped, the work order was issued, and the memorandum that is
No, the project was dropped only on 14 August 2015.
no, Lordship. 1st April 2014. 1st April 2014.
1st April.
Yes, Lordship.
Where is the
Para
communication?
Lordship.
Where do we find the communication?
Lordship, para 4.
The
That is the Jawaharlal Nehru National Urban Reserve Mission that was dropped on 1st April 2014.
No, where do we find this letter?
I
1st
have not
April
enclosed,
2012.
I have not enclosed the letter, Lordship. But in any case, the project has also been dropped, and the Lordship, the notification dated 6/8/2015 was only to reiterate that the project has already been dropped.
What do you say about this office memorandum, March 4, 2014?
Lordship, I have not been supplied a copy of the affidavit in reply by the government, so I'm not aware of this memorandum also.
Your office memorandum
I do not have a copy of
dated
the
March
affidavit.
4, 2014.
No, Lordship, in one similar case, it's not similar,
Hmm.
but in one case that has been decided by this honorable court. Here, the project was dropped. However, the work order was issued before the project was dropped. So that is why that project was revived by the central government. But this case is different. In this case, after the project was dropped, the work order was issued.
Now, whether the project was dropped on, according to you, is
Yes.
1/4/2012.
Yes, ma'am.
Whether this dropping of the project, whether this was communicated to the state.
Lordship, in my affidavit, it is cited that in my affidavit, it is stated the state government was well aware that the fund has not been released, and the project and the said project and the transition phase has also ended on 31st March 2014.
But
I have categorically stated in my affidavit, Lordship.
but the memorandum, your office memorandum, March 4, 2014, clearly says that
Memorandum.
the details of the project.
Copy the
1098.72 lakhs for the project name, name of the town, Chumukeduma.
Yeah.
So this is there, 875,
Lordship,
875.
my Lordship, can you see the memorandum is dated 4th March 2014,
Yes,
and the project was dropped with effect from 1st March, April. So
No.
this memorandum is March,
then
and the
what,
project was dropped on April
no, where is
after
the
the memorandum.
where is the communication?
Lordship, I have not enclosed the communication.
Okay, that,
I'll
how do
produce,
we know then?
I will produce the communication, Lordship.
And then you see subsequently under office memorandum 14 August 2015, here only you have, of course.
This is to reiterate our earlier.
Hmm?
This is just to reiterate the earlier or earlier project. That is the
No, here-
JNNURM.
It doesn't say that. It only says that all projects which
Yeah.
were approved, but
Yes,
funds could
that
not
is
be
approved
released.
under the JNNURM.
Yes.
Approved under all projects that was approved
Hmm.
under the JNNURM.
Stand dropped and will
Yes,
not be considered for funding. That is on 14 August 2015
my
only.
lord, my lord.
And by that time, the contractor has already executed.
The lordship, see, the Jawaharlal Nehru National Urban Renewal Mission
Hmm.
expired
Hmm.
expired with effect from
Now you have to show and satisfy that you have communicated this, that the project was dropped in the, on 1/4/2012. And despite of this dropping of the project, then the state has issued, then I think the state has to decide.
Lordship,
But we have to show,
let me give, Lordship, may I fix this after a week. I'll produce the letter.
you file by additional. That will be necessary, otherwise you are liable, it appears. You want to file
I'll file, Lordship.
by way of affidavit,
Yes,
additional affidavit.
madam.
My lord, if it's by way of an affidavit, then they may send for waiting and then it may take some time, so they can just produce the document.
Hmm?
No, your lordship, if I told they are producing it, the state have to contest that. So let it be in the form of an affidavit.
You have to file, you should have actually. Hmm. So how much time? 1 week,
3 weeks, Lordship.
3 weeks?
It was, it's from Delhi.
Okay. Hard. Hard, Mr. The petitioner is,
And Longkumar, my lord.
Mr. N. Long Kumar, land counsel for the petitioner. Also heard Mr. N. Angame,
Lordship,
land Senior Government Council for the respondent number 1, 2, and 3.
1, 2, 3, and 4, my lord.
1, 2, 3, and 4. And also Mr.
Yeah, what it is. Never has a good name.
Mr. You are,
Yeah, what it. CCC.
okay, CJC. Stop. For the respondent number 5.
No, no.
Okay, stop, Then it. CJC wants to produce some documents related to the dropping of the
Projects.
what is the name of the project? Jawaharlal Nehru,
Jawaharlal Nehru. In short, JNNURM.
Jawaharlal Nehru National Urban Renewal Mission, within bracket JNNURM, bracket close. And prays for 3 weeks' time to file the said document in affidavit. Stop, Is prayed, is prayed for by the CJC, comma. Sorry, no, that's all. Just a minute, The prayer is allowed, The prayer is allowed. So, list this matter after 3 weeks. You serve copy,
After I file also.
Okay, first you file,
Yes.
then they'll see and they, okay. Yes, fine.
Consolation.
For admission, item number 5.
This was 4, no? Okay.
made, please, Your Lordship.
Yes, please.
Your Lordship, this honorable court by the order dated 28/8/23.
Yes. Order
Directed.
dated of this court.
Yes, order dated 28/8/23.
28/8/23. Yes.
Directed the petitioner to implead Deputy Commissioner Chomokidima as the respondent number 3.
Okay.
And accordingly, Your Lordship, I have made a recast petition and I have submitted before registry today.
Okay.
And whether it has come or not, I do not know. However, Your Lordship,
Yes.
I have only implemented this Deputy Commissioner Chomokdima as respondent number 3. The factum of the case, Your Lordship, in nutshell is that my father, he sold a plot of land to industry department way back in 1985, Your Lordship.
Okay.
Way back in 1985. A sale deed was executed between my father and the department, where in clause number 6, it was like that. I'm just in nutshell.
Yes,
I'm just
yes.
in clause number 6, it was there was a term that the land was given for Citronella project, and if the purchaser divert from the project, abandon the project, then land will be returned.
Conditional sale.
Conditional sale, Your Lordship.
Yes.
Now, Your Lordship will appreciate that section 29 regarding of the Indian Contract Act, it says about this voidable contract, but section 32 of the Indian Contract Act, it says that contingent contract, if any contract is made between the parties for doing something in future or not doing something in future, then it will start its effect. Now here,
which section? 32.
32, Your Lordship, contingent contract. So now, Your Lordship, accordingly, Your Lordship, the land was given to railway. A portion of the land was given to railway department for railway line, diverting from the project. And railway department.
Originally, it was conditional sale was executed
For
between
Citronella project.
with
me and Director of Industries.
okay, industry.
Industry.
So subsequently, it was given to railway.
Railway.
Some portion.
Yes, a portion of the land was given to the railway for railway line.
Okay.
Now, Your Lordship, railway department has granted compensation.
Okay. Compensation to?
Compensation in favor of the landowner. Landowner means in favor of the industry department.
Okay. Now the industry is okay. Now industry is owner after purchase.
Yes, after purchase. They have given this. So when we come to know about the factum there, railway has released a fund for making payment to industry department to pro forma respondent number 1, Deputy Commissioner Dimapur.
Okay.
Then we filed one civil suit before the learned Civil Judge Senior Division in Dimapur that for a decree of our right pertaining to the land which was sold on as a conditional sale and since diverted from the project, so the land compensation should be given to us.
Yes.
Now, Your Lordship, along with that civil suit, we filed a IA.
Okay.
Under order 39 rule 2.
Okay.
Praying before the honorable court to restrain this Deputy Commissioner Dimapur, the pro forma respondent number 1, from releasing the compensation amount to the industry department till final disposal of the suit.
Praying for injunction.
Yes, Your Lordship. Accordingly, learned Civil Judge Senior Division has granted interim injunction.
Okay.
Against which, against the order of the interim injunction under order 39 rule 2, the industry department filed one appeal before district judge.
Okay.
Before the honorable district judge under order 43 rule 1.
Okay.
Read with section 104 of CPC.
Order 43.
Rule 1.
Okay.
Read with section 104 of CPC. wherein it is said that there are certain orders which can be appealed before the immediate next year. So accordingly, Your Lordship, the learned district judge Dimapur, he has reversed the order, injunction order, he has reversed. Reversed means he has vacated the order. Against which, Your Lordship, we are here before this.
Appeal lies against the injunction?
Yes, Your
Whether-
Lordship.
Okay,
Order 43 Rule 1,
okay,
appeal lies. With all fairness, I submit that appeal lies.
okay,
And this is the CPC's order.
right.
Now, Your Lordship,
Hmm.
now when the order was rejected, reversed, this injunction order was again set aside. Then we have come before this honorable court by way of civil revision.
Okay, this is by way of revision.
By way of revision, because since there was appeal, so I have to come as a revision.
Okay,
So I have come as a revision before this honorable court.
okay.
Now, Your Lordship, this honorable court was pleased to issue this temporary stay also. Now, in the meantime, this Dimapur district it has been bifurcated, Your Lordship. Bifurcated as Chumukidima district and Dimapur district.
Okay,
Now, my land, it falls under Chumukidima district.
okay.
This honorable court taking into consideration that since it has been transferred to Chumukidima district, so Chumukidima deputy commissioner should be a party. Otherwise, while in execution, it will be a problem.
It will be.
Accordingly, this honorable court, by the order dated 28/8/23,
Yes.
directed me to implead
Hmm.
Deputy Commissioner Chumukidima as respondent number 3,
Okay,
pro forma respondent.
okay,
The main respondent is
right,
my landed friend, this industry department.
okay.
Accordingly, Your Lordship, actually, Your Lordship, during this puja, and I was also seeing out of my station for a long
Okay.
time.
Okay,
So today I have filed, Your Lordship, this
okay,
petition,
okay,
recast petition, including this Chumukidima Deputy
Okay.
Commissioner as pro forma respondent number 3.
so then the earlier deputy commissioner, that was which district?
The DC Dimapur.
This is Dimapur.
Then actually money was kept with DC Dimapur.
Ach,
Then in the meantime, Your Lordship, since
Okay.
the bifurcated district,
okay,
so DC Dimapur probably was not having all the records have come to Chumukidima DC.
but then since the money is with the DC Dimapur till that,
Now, so I do not know whether this government can say with whom the money is.
okay.
Probably with Chumukidima, no? Chumukidima. So accordingly, I have now implemented Chumukidima DC as
Okay,
pro forma respondent number 3.
okay,
And I crave your indulgence that, Your Lordship, I have filed today only.
okay.
So whether this hearing can be taken, please, or not, now this is up to the honorable court.
So now.
If my lord may kindly
Have to
appreciate,
give,
I am for the respondent number 1 and 2, that is the Department of Industries and Commerce.
okay,
And as far as the impleachment is concerned, as one of the respondent parties, it's just a formality, lordship, so that as my learned senior colleague has already mentioned, for the convenience of execution, and apparently the money is already with the Deputy Commissioner Chumukidima. So as far as the argument is concerned, lordship, it is only on the limited question of law, whether when the land has been bought and it has been paid in full, whether such restriction in terms of contingency contract will apply when it is a matter of transfer of property where it has been outrightly purchased. That is the only limited question of law, lordship. And as far as my learned senior colleague is concerned, he says it is a contingent contract. I am saying it is an absolute sale, absolute purchase. So whenever there is nothing to give and take, I have decisions, authorities of the Honorable Apex Court.
what do you say about the the condition?
No, that is why, lordship, such condition, if it is part of the agreement, that condition itself is null and void. I have authorities to supplement my argument, lordship.
Okay. Whether this plea was taken before the trial court?
Yes, lordship.
Okay.
And
It was taken, this,
Your Lordship,
yes, in the first appeal, I have prevailed, and the learned district judge, Dimapur, has also reflected my argument, upholding the submissions advanced. And I have authorities also. One of the main grounds that my learned senior colleague for the petitioner, the appellant, the revisionist, is also taking is that Transfer of Property Act is not applicable in Nagaland. I have authorities to show also that the spirit of law applies. Lordship, the law cannot be nullified by the interpretation of any of the parties. Spirit of the law applies. So I have authorities, and since it is on a limited question of law, if my lord is not averse to taking up the matter today, I'll be very happy to assist this honorable court and my learned senior colleague in arguing the matter today itself, my lord.
I just come on.
Hmm.
Whether this petition, Rika's petition is there or not?
No, it's not there. It is not yet come. So,
No.
Then we can take it up maybe in a week's time.
I think it will be good. Your lordship,
yes.
my learned friend has stated that for academic discussion, your lordship,
Yeah.
Transfer of Property Act is not applicable in the Nagaland by that as a matter of principle, it is applicable. But your lordship will appreciate that there is a article provision, this 371A article, whereas it is categorically stated that no act of parliament is enforceable in the state of Nagaland until and unless adopted by the state through a resolution. Now, regarding this Transfer of Property Act, your lordship, no such resolution has been adopted by the state till date.
Okay.
So when there is the applicability of law is not enforced in the state of Nagaland, how this Transfer of Property Act will come into force? So this is the this point has been taken. This is the wrong notion of the learned district judge, taking into consideration of Transfer of Property Act. Now, your lordship, I have also gotten of judgment wherein this honorable apex court has said that when there is a contingent conduct, the whole and in the event of any agreement, whole wording of the agreement should be taken into consideration by the honorable court while taking such decision. Now, the clause 6 of that agreement 1985, Industrial Department has categorically agreed that if the land is diverted for any other project except Citronella or any other abandoned, then it will be returned back. Now, your lordship, the question comes whether industry director is not illiterate. They are officers, they are not illiterate, they are expert and they are well educated. So at that point, if it would have been a rustic villager, then the question comes. But here they have knowingly they have signed the
thereafter also no challenge.
Yes.
No way.
So your lordship, anyway, your lordship, after
Anyway,
wondering.
after. So it has also not come here.
Yes, sir. Yes, sir.
Okay. Had Mr. P.V. Paul, land counsel for the petitioner. I've also heard Lanet.
Joshua Shetty.
देखो पता नहीं पते
Joshua.
not Joshua. Okay. Land counsel for
The respondent number 1 and 2, lordship.
the respondent number 1 and 2. Stop.
Yeah, please, my lord. Lordship, I'm for pro forma respondent number 1.
Okay. And Mr. His name, huh? For the pro forma respondent number 1. Stop, huh? Era. Land counsel for the petitioner, Mr. P.B. Paul, submitted as per the direction of this honorable court on 28/8/2023, he has filed an affidavit impleading
Rika's petition, your lordship.
or Rika's petition impleading the deputy commissioner Chumukedima as the party respondent number 3 in the
Pro forma respondent. Your lordship.
pro forma respondent.
Yes.
Okay,
But
pro forma
see-
respondent in the civil revision petition. Stop. Civil revision petition. The same has not been placed before this court today. Stop. Huh? So this will be after.
Your lordship, if your lordship on Monday, your lordship is there on Monday or on?
Yes,
Then your lordship on Monday, it may be please.
Monday.
Monday. Or Tuesday, convenient to the honorable court. Monday, we also want to finish the matter. Monday or Tuesday, convenient to the honorable court.
If possible, Monday, Lordship.
Monday, oh, Monday,
No, just
six.
Six.
Six,
Monday is the
11,
sixth.
6 November.
Let us keep it on 13. Next Monday?
Next
13.
month. Next Monday.
13.
Yes,
Your lordship is here.
yes,
Okay.
okay. So as prayed for by the land councils for the parties, put up this matter on 13. 11, 13, 11. Usually for admission.
Admission hearing.
Okay, admission here.
Our pleading also completed.
Otherwise,
Admission hearing. Better,
want to keep it in,
admission hearing, Lordship, if, since my lord has already mentioned,
okay,
will accept that, my lord.
admission hearing.
My lord.
Okay.
Lordship. Oblige, your lordship.
Yes.
For admission, item number 6.
May I please, your lordship?
Yes, please.
Your lordship, here the petitioner is approaching for releasing of the vehicle, seized vehicle on Zima, your lordship,
Okay.
in connection to chart 337/23,
Jimma of what? Vehicle.
Eldo LXI.
Hmm?
Eldo LXI.
What is that?
In for releasing of Maruti Eldo LXI.
Okay, Eldo.
Yes.
Eldo. Have you applied before the,
Yes,
Trial
your
court.
lordship, after the incident, the applicant had approached the learned magistrate court
okay,
before the,
what order was passed by the magistrate?
your lordship may kindly see my annexure 4, page 14, your lordship. This is the rejection order which was passed by the
Or rejected?
learned, yes, learned
On what
magistrate court.
ground?
Your lordship may kindly see my last para lordship,
Yes,
page
please.
14, your lordship, I may be
Yes.
allowed to be.
14. Yes,
Learned DPP has, however, objected to the release of the vehicle based on the status report of the IO concerned. Whereas the report furnished by the IO, wherein the IO has submitted that the vehicle is required for further investigation in order to ascertain the real owner. Considering the above facts and circumstances, well, the primary object of the provision of interim custody is to ensure that the owner of the article would not suffer because of its remaining unused or because of its misappropriation. Yet, however, when the ownership has not been established to release, the property would defeat the object. Your lordship, this is the dismissal order, which was rejected on 12/7/2023, lordship.
so who is the owner then?
Your lordship, however, your lordship here, after the rejection, the Zima application was filed before the learned magistrate court by the registered owner in the smart card, who is the real owner. However,
No,
it was
this Jimma was, for Jimma, this application was filed by whom?
By
Earlier,
the-
before the trial court?
by the registered owner,
Registered owner.
Yes, as per the smart card.
Then, but then this order says that ownership is not clear.
Your lordship, however, it was mentioned that as per the status report, the IO could not able to investigate as to ascertain the real owner. However, after lapses of so many months, the investigation officer has stated in that way. However, your lordship may kindly see my page 12.
12.
Yes, it annexure 3, lordship.
Yes, what is that?
Yes, your lordship. Your lordship, here is the registration card, which was issued against the name of the petitioner, owner name Longgong Sin Lachang. Your lordship,
Owner name? No,
yes. She is the
sorry,
owner itself, lordship.
just a minute, where do we find owner's name? Where do we find the name of the owner?
Yes, Lordship. The petitioner is the owner of the,
Just a minute. Where is the name of the owner? It said owner.
yes, at page 12, annexure 3.
Oh, page 12.
Yes, Lordship. Owner name.
Yes.
Yes.
Longkosong Chang. So the petitioner, what is the name of the petitioner?
Lungkong Senla Chang, Lordship.
Okay.
Lungkong Senla Chang.
Longkong Songla Chang.
Yes, Lordship.
Longkong Songla Chang. Yes. He made this application before the trial court also. He was the applicant.
Yes, Lordship.
No, this is Srimati. Just a minute. Okay, Longkong Songla Chang. She is the owner of the vehicle.
Yes.
But then
Your-
why it is say that considering the fact that the owner of the article, owner of the article would not suffer. Just a minute. When the ownership has not been established to release the property would defeat the object. So this was the ground. for rejection.
Yes, Lordship.
So on what ground it was said?
Your Lordship, for that, I do not know. That is why being aggrieved, the petitioner is approaching this honorable court, Your Lordship.
No, the petitioner purchased the vehicle from Mr. Wan Sherman.
Your Lordship, here the facts is that
Hmm.
on the fateful day, that is on 4/6/2023, in connection to this case, one alleged accused person was arrested. Namely, one alleged accused person was arrested in
Okay.
connection to this case,
Hmm.
same among.
Yes.
So on that fateful day, on the morning, the accused person had approached the owner of the vehicle for purchasing the said vehicle for the consideration of rupees 1,80,000. Now-
Accused. What did you say? Accused? Well, name of the accused is
Same among, Lordship.
same amount approached.
The owner of the vehicle, who is the applicant in this,
Whom? Longkong Songla or
from the Longkong Senla.
no, the Sherman.
Yes.
Sherman was earlier owner.
No, same among, he is the accused person in connection to this case, who was arrested in connection to
Oh,
this case.
Sherman is the accused.
Yes, who was arrested in connection to this case.
Okay.
Now, Your Lordship, the facts is that on 4/6/2023, in the morning, the accused person, the same among, had approached the
Where have you stated that?
at para 3, Lordship. Your Lordship, may kindly see my para number 3.
Yes,
Yes, Lordship, I may be allowed to read it, Your Lordship.
please.
On the facts of the case on 4/6/2023, the applicant was approached by the alleged accused, namely Sam Among, to sell the vehicle for his
Same
personal.
amount.
Yes, he is the accused person.
The order, not same amount. It's a Sherman.
Yes.
It's a different again.
Same Among.
Hmm?
Same Among.
Same amount.
Yes.
Okay.
So to sell the vehicle for his personal use. Accordingly, the applicant, who is the applicant in this present Zima application,
Hmm.
had agreed to sell his vehicle on the consideration amount of rupees 1,80,000. It is pertinent to state that the alleged accused had requested the applicant to pay rupees 1 lakh and advancing the remaining amount of 80,000 will be paid back within a week. The applicant and the alleged accused had agreed to execute the sale agreement for sale only on the payment of full amount. However, later on, the applicant learned that the alleged accused was arrested in connection to the instant case, and the vehicle has been seized by the police personnel. Hence, the applicant had approached the accused person in families to revoke, cancel the sale of the vehicle, and also stated that she will repay the amount that he had paid by the accused person. Your Lordship may kindly see my annexure.
No, whether the half of the amount was already paid.
Yes.
1 lakh was paid.
Yes,
So you
Half
are no
of
more the owner then?
No, half of the amount was paid to the applicant, to the Long.
No, that is, now you are no more owner.
No, your lordship. So after the incident, in the morning, the accused person had paid that half amount of money.
Return?
Yes.
No. Accused in the incident morning, accused paid
Yes,
1 lakhs to the applicant,
to the owner of the vehicle.
owner of the
the
applicant, and then
So,
accident took place.
yes, so later on, the owner of the vehicle had learned that his vehicle has been involved in one accidental case. So after learning about that incident, the owner of the vehicle had approached the sisters, families of the accused person in order not to resell, in order to revoke the sale, as full payment had not been made. So accordingly, they have also made a affidavit declaration, your lordship. Your lordship may.
In absence of the accused, who has purchased, the person who has.
Yes, in the absence of the accused. However, after thorough discussion with the accused, they have already revoked the sale of the vehicle.
What about the money? Money repaid?
Yes, money has already been repaid to the accused family.
Okay, where do we find that?
Lordship may kindly see at annexure to page 11. At page 11, lordship. This is the affidavit.
Affidavit was signed by
the
owner and the other person, not the accused who took the vehicle. This is some other person, Matu, sister.
Yes, sister. That is the family member of the accused person, your lordship.
Oh, because of this confusion.
Yes. Only because of this, his vehicle, the petitioner vehicle has been seized. Now, your lordship.
Now, whether the accused is still inside a jail?
No, lordship. Your lordship may kindly see at page 16, annexure 5, lordship. On the day of arrest itself, he was released on bail since the sections were available in nature, your lordship. I may be allowed to read the. Yes. As such, on considering the submission made on perusal of the CR, it appears that all the charges leveled against the accused person are bailable. As such, should the accused furnish bail, this court has no reason to reject the same, your lordship. Your lordship, even in connection to this case, the accused person who was arrested, he was also released on bail, your lordship.
No, but this, you kindly see the order, but in the order, it is some other name has been mentioned. Council for petition submit that the petition.
Your lordship, even in the order itself, the petitioner is the one who is the present applicant in this SEMA.
The petitioner had purchased the vehicle from, one Sherman. The petitioner has also purchased from. This was incident took place on. Incident of accident took place on.
On 4/6/20.
Okay, this was earlier. For the respondent.
Lordship.
Oh, yes.
Lordship,
So,
I would like to.
what is your submission, whether you were asked to identify the owner? Sorry, the investigation IO was directed to identify the real owner of the vehicle,
Lordship,
whether identified.
I would like to submit the status report.
Okay, please.
Lordship, as far as the latest status report is concerned, more particularly paragraph 2, starting from paragraph 2.
Yes.
Furthermore, He stated that he had purchased the vehicle on three.
Who, he means who?
He, the accused, Sam Omang.
Okay.
He had purchased the said vehicle on 3/6/23 evening and was on his way to his sister's house the next morning, that is on the day of incident,
Yes.
04/6/23, to show his sister. However, unfortunately, he met an accident at Badampugri, Dimapur. It also appeared that no FIR with regard to the vehicle is made in any police station within the jurisdiction of Dimapur. As such, the question as to who is the real owner of the vehicle is doubtful. As the accused stated that he had purchased the vehicle from Dimapur, even though the vehicle is in the name of Long Kong Song La Chang, Lordship, the present petitioner, Lordship. So as of now, the real owner has not been ascertained and it is still doubtful, Lordship.
Now the
As
accused
far as-
accused is claiming the vehicle to be his
Yes,
and to have purchased from you.
No,
Lordship.
no, Lordship.
Hmm.
Here, the facts is that the accused had purchased the said vehicle from me, from the owner of the vehicle.
Now
No.
you have, first you have to decide
Lord,
who is the
yes.
owner.
Yes,
Releasing, no problem.
Yes, Lordship,
that has
the
been-
present petitioner is the owner, Your Lordship. Your Lordship, even the registration card, even in the RC.
Yeah, that is true. That is true.
Yes.
But then admittedly, you have also stated that he purchased in the morning.
Yes.
On third.
But as far as the status reports,
Now the accused is claiming,
Lord,
seems accused is claiming to be the owner of the vehicle.
No, my lord.
Hmm.
My lord, here where the owner of the vehicle have discussed among the family members with the accused family, and then mutually they have agreed that the vehicle,
No, just
The
a
sale of-
minute,
yes.
just a minute, huh? So you have submitted this one, this agreement affidavit.
yes, yes.
So this was signed on 11 July.
Yes, lordship.
11 July,
11/7/2023.
he was out of jail then. He was very much there.
yes, Lordship.
So
No.
why the accused himself has not signed?
Lordship, since the accused is in the judicial custody, so the owner of
Accused
the,
is in the,
in the judicial custody.
no, now he is no more in the judicial custody.
No, my lord. Still he's in the judicial, although bail was given to the accused person,
Yes.
the family members have, still, they did not taken him from the jail. So on
In the
11th
bailable offense.
Yes, yes, yes,
Why?
for that. So on discussing with the members of the accused, on bail, the sister of the accused person had already declared, your lordship.
No. See, the accused, what is his name? Sam Among, huh?
Yes, Sam.
Sam Among is the person who is said to have purchased the vehicle from the applicant.
Yes, lordship.
So he has to sign the affidavit
Yes, Lord.
that he has received back the the amount which he had paid earlier as an advance.
Okay.
That is that is rupees 1 lakh.
Okay.
And then now he has no more claim,
Okay.
no more grievance against the main owner. So
Okay.
he has to sign, not the sister. Sister is a stranger.
Okay, okay.
So bring that order,
Okay.
bring that affidavit,
Okay,
annex here,
okay, lordship. Okay.
let him declare. So
Yes,
that I think the ownership will be clear.
Yes,
Yes.
Lord.
Once the ownership is clear,
Yes,
yes, releasing the vehicle on Jima would be no problem.
yes, yes.
Lord.
So when can you bring, when can you produce?
Within a 1 week, lordship.
Within a week.
Yes.
Mr. Positim Zhang. Ponginer, land counsel for the petitioner. And Mr. Bitovi. Okay. Zimomi, land public prosecutor, Nagaland. Stop. Mr. Vito V. Jimone, land public prosecutor, produced a status report in connection with GR number 373 stroke 2023, wherein the eye of the case stated that the question as to who is the real owner of the vehicle is doubtful, as the accused, what is the name of the accused?
Sam Omong.
Okay, Sam Omong. Sam Omong stated that he had purchased the said vehicle from Dimapur, even though the vehicle is in the name of the applicant Longkong Somla Chang. Stop. On the other hand, the land counsel for the petitioner, Mr. Tosi Temzen, Pongener, submits that on the next date of the incident, on the same incident or same morning, same day of the incident or next day?
On the same day of.
Okay, on the same day of the incident, the advanced amount of rupees 1 lakh was returned to the alleged accused stroke purchaser Sam Among, Sri Sam Among, and to that effect, his sister had executed an agreement. What was that? Affidavit.
Yes, Lordship.
Showing that in the affidavit, she said that she has received.
Yes, Lordship, at para number 2, Lordship.
There are two.
It has only been stated that the remaining amount to be paid within a week.
Oh, this is also, see?
Lordship. That also not paid.
Your Lordship, para number 3, Lordship.
Para number?
3. However, on learning the unfortunate incident, the owner and the family members of the alleged decided to revoke, cancel the sale of the vehicle by reaping the same to the alleged accused families.
Okay. And stated that the that the said sale deed was also executed to that effect.
Yes, yes, Lord.
Right, sale deed executed between the accused and the owner of the vehicle shall be revoked. Stop. Huh? And however, as the affidavit or return of the money or the revocation of the sale deed has not been executed by the accused stroke purchaser, Sri Sam Omong, the petitioner raised for some more time to produce a document showing that the sale document that the said sale of the vehicle has been revoked. And prays for some more time, huh?
Yes, 1 week, Lordship.
1 week, prays
Yes.
for 1 week time, stop. Huh? The prayer is granted. List is matter after 1 week. In the meantime, the petitioner shall submit the document showing that showing her ownership of
Yes.
showing her ownership of the vehicle by filing additional affidavit
Okay.
to the application. Okay,
Much.
to the criminal petition, huh? Okay.
For admission, item number 7.
Yes.
My lord, I crave your indulgence in item number 5, your lordship.
Yes.
There was an interim order on
Okay.
restraining the.
It was continued
Yes.
continued, okay. In item number 5, the interim order passed earlier shall continue.
And your lordship, the matter is ready. So at 2, if your lordship allow me, then notice may be issued to the performer respondent. Then on 13, the matter can be finally heard.
Okay.
Lordship, as far as the earlier order is concerned, everything is okay with it, except the part where notice has to be issued, but until and unless the file reaches your lordship's table from the registry,
It will not be.
notice cannot be issued.
Yes.
No. Cannot.
That- So, my lord, may kindly, for issuance of notice to the performer respondent number 3, who is again represented by my learned friend, Mr. K. Angami, the learned senior government advocate. So for issuance of notice, that particular sentence may be included by calling for the file to be taken up on today at 2 o'clock, lordship.
Okay. Today, in today's order.
Yes, lordship. For issuance of notice, until and unless notice is issued, it will be a problem, my lordship.
At 2, if your lordship take up the matter.
Let it come at 2.
Yes, your
Yes,
lordship.
my lord.
Much obliged, much.
Bless you, lordship.
Yes, this is.
Now, my lord, coming to item number 7. Your lordship will kindly appreciate few developments in the case. First is, my lord, a status quo order was issued when this regular second appeal, RSA, was moved before the Honorable Court. The status quo order was issued by order dated 3/11/2021. 3/11/2021, status quo order was issued. Now, my lord, when this matter was pending, the appellant, Mrs. Khotuli Awami, she passed away.
Okay.
Lordship, after that, IA Civil 28 of 2023 was filed by his nephew, by her nephew, to replace her as the legal heir. Then subsequently again, IA Civil 48 of 2023 was again filed by her stepson, again to replace her as the appellant.
2%.
Two persons,
So there
one
is a
is by her nephew and the other is by her stepson.
Oh, so dispute.
Yes, your lordship. That is why by order dated 19/6/2023, the matter was referred to the family court Dimapur
Okay.
to settle the issue and who will be the appropriate legal heir to represent the deceased appellant before the Honorable Court. 4 months' time was granted.
Okay.
Lordship, unfortunately, due to the absence of witnesses who could not appear on time whenever summoned by the court, the matter is still pending. But in the meantime, Lordship, I may be allowed to place some documents on record before your Lordship.
So on behalf of? The
Totally.
documents will be on behalf of?
I'm appearing on behalf of the appellant.
No,
But here, Lordship.
No, appellant, because appellant now the 2% claiming.
No, I'm appearing in the IA number 28, which is now IA 48, IA 28 and 48 both are referred now to the the
Yes, yes,
lower court Dimapur.
yes, you are in the 28
I am in the 28,
for
Lordship.
nephew.
Yes, Lordship. No, yes, Lordship, for nephew, my lord.
Mhm.
Now, my lord, if my lord may kindly peruse these pictures. Against the status quo order, the respondent and his stepson, who is now claiming to be her successor, they have demolished the house. So, my lord, here is now an issue where nobody is now the rightful successor. That is yet to be decided. But in the meantime, taking advantage of the pending issue, the house which was resided earlier by the late appellant is now demolished
By
by the
stepson.
respondent and the stepson who is appearing in the IA number 48, Lordship. This is the picture evidence of the entire house being demolished.
Who is the respondent?
The respondent is one V. Ho Awami.
And he is
He was the ex-husband,
or ex-husband.
ex-husband where their properties have been clearly divided between the two parties. There was a clear division of properties where half of the part is owned by the respondent, that is V. Ho Awami. And now in IA number 48, IA civil number 48 of 2023, the stepson also wants to be the successor of the late deceased appellant. Now, Lordship, during the prevalence of the status quo order, while the matter is still pending, the sole respondent, Mr. V. Ho, and the applicant in IA number 48 of 2023, they have demolished the entire house. My lord, may kindly come to the last page.
No, that will amount to.
It amounts to contempt, Lordship. Lordship. So, my lord, here, my learned friend, kindly allow me to finish this part. Now, my lord, here is an issue where nobody is now decided to be the legal representative. So, my lord, it is my humble request that my lord may issue suo motu contempt because it is directly against the violation of the status quo order. Whether the respondents do not understand the meaning of status quo, whether it is in the knowledge of the councils or not, that I do not know. But if it is in the knowledge of my learned friends, it will be very unfortunate. It's clearly a contempt of the court, Lordship. A suo motu contempt notice may be issued, my lord. That is my humble prayer.
May I please, your lordship?
Yes.
Lordship, the status quo order was in favor of the appellant. Now the appellant has expired, has died. So the status quo order has abated. That is the position of the respondent.
Status quo order is?
Has abated. Because the appellant has died.
Now you see, appellant will be replaced either by the nephew or the son.
Yes.
The stepson.
Exactly, your lordship.
So that is pending. The status quo remains. It will either remain in favor of the nephew or the stepson, but then that stands. The order stands still.
Respectfully, my lord. It's actually a very dangerous submission that caused by my learned
That will
friend.
be difficult. That will be difficult.
That's a very dangerous submission, lordship.
Lordship, but the demolition.
Now, how
the
the order will
demolition
die?
part before that they had filed the application.
No, Sri Lanka Council, please, you are representing the respondent in the RSA.
Lordship. So, Lordship.
So you are with stepson. Stepson. No, you can't. You can't do that.
There is another counsel for the stepson, lordship.
Stepson, another council.
Yes, I'm appealing for the stepson in the I.
Now, who is demolishing? Who is demolishing?
Both of them together, lordship.
Now
And
they have become party.
I request your lordship not to record the submission of my learned brother because as learned brothers,
No, that
I want to protect him also. But my lord, that is a very dangerous submission as if it is done in their, according to their advice. If it is their understanding that, if it is their understanding that
not what.
Interim order is already vacated by the date of the appellant, the issue is still pending, lordship.
Lordship,
That submission may be
demolition
recorded,
took place
lordship.
before that they had filed the
One at a
application.
time, one at a time.
My lord, if my learned brother understands, he should recall that submission. That will invite the same
Yes, yes.
Yes, the same
Anyway,
upon himself also, Lordship. That
Lordship.
submission may kindly be recalled. my lord.
Lordship, the demolition took place before the application was filed by the present.
No,
No,
Lordship,
no, no,
that
but-
is highly misleading again. How many times
No.
misleading submission will be given? That is very unfortunate. Respect should not be misunderstood, my lord. That is my humble submission.
Please. So that cannot be, whether the person has died or before or after the filing of the application photograph, but then this, the status quo order was passed, that still stands. Yeah.
Lordship, after
So-
the appellant
Unless it is
died,
vacated, unless it is vacated by the court. It will not be vacated at the death of the person. Because the death of the person will be replaced either by the nephew or the stepson.
Yes, my lord.
Unless it is vacated by the court, it stands only. So please don't make that submission. So, now since, whatever has been done, so, let it, you see, kindly maintain the status quo as per the order, otherwise you see, it
No,
will
my
be
lord.
difficult even for the learning council. Also, you have submitted and it has been recorded also. Please don't, instruct your client not to do any further action on it, no? Not to do any damage, any further damage to the property.
Lordship,
Okay,
the
till
property is already damaged.
Hmm.
The entire property is damaged.
But
So,
we also do not know what was the status quo earlier.
the status quo was when the house was in the first page, Lordship.
Mhm.
The full house was there. This
So-
picture was taken during the funeral service.
Hmm.
This is the full house.
Hmm.
Now this is the entire house, and very recently,
Hmm.
this is the present
Now,
status of
now
the
you
house.
see, now after the decision of the decision that who would be the ownership, then he has to, you see, I think compensate later on, if that comes later on, that will.
My lord.
Hmm.
But any further
but then
action,
for the
Lordship,
time- for the
contempt
time being-
may be initiated, Lordship.
So for the time being, you see, the clear instructions should go from the learning council to your client. Not to do any further, okay?
Okay.
And then since the case is pending between the nephew and the stepson, let this case be proceed.
Lordship.
Okay, so let this case be trial court decide the matter. And then thereafter, and then here in this case,
Lordship,
what?
it is my humble
why it has come
request,
for that?
my lord.
Yes,
I have a very humble request for your lordship's consideration that a speaking order with a very stringent observation may be given. If not, there is no respect for the status quo order that has been passed by this own court. And this is very unfortunate, lordship.
you, in that case, of course, that can be there, but then you have to submit this in the form of affidavit.
Lordship, who will file the affidavit?
Oh,
Now,
that is difficult,
yes, it is pending, lordship.
Hmm.
So taking advantage of the situation where, who knows, it doesn't matter whether the stepson becomes the legal heir, no issue. But
at the moment,
during the
since-
pendency of the status quo order, how can they be allowed to go and demolish the entire property? And my learned brother, please show some respect. If not, I will insist upon the honorable court to initiate contempt against you also.
So in which court it is pending for decision of
Lordship, before the district judge Dimapur.
district judge? There also
Yes.
this need to be informed that some order need to be passed.
My lord. Yes, so my lord,
There.
because
In
of
that
the
court- in that
witnesses,
court.
the witnesses who are not,
Hmm.
who
in-
are,
in
some
that-
are
in
out
that-
of station,
in
that
that
is why
court,
the issue is still pending.
In that court, during this pendency, and then since the opposite party,
Lordship.
uh,
Any further action against the status
that-
quo order will invite a contempt.
yes, that the district court where the case is pending, that also can pass an order.
No, lordship, as
Would
far
have
as
been for-
contempt is concerned, it is the jurisdiction of the honorable high court, my lord.
Yes, that is there.
Yes, lordship.
What was the last order? Last order? Whether the case between the nephew and son is pending before the district court has been reflected in this, in this case, in any order,
Order 19-6, 2023.
19-6.
19-6, that is the last order.
Yes, Your Lordship, 19-6.
In RSA.
Yes, Lordship. The second last part of the paragraph, Lordship, will see that the learned principal district and session judge Dimapur shall complete the exercise within a period of 4 months from the date of receipt of this order. Due to some practical difficulties, the matter is still pending, Your Lordship. So, my Lord, may kindly list this matter after 1 month if my little brothers are okay with it. 1 month.
By which order the status quo was passed? Status quo order?
Oh, Lordship, the status quo is 3/11/2021.
Yes, yes,
May I read, my lord?
yes, yes, it's there.
Yes. So the main last paragraph, Lordship. In view of the submissions of both the learned councils, it is hereby directed that the status quo of possession of the applicant over the house standing in the land mentioned above be maintained till the disposal of RSA 1 of
Now,
2020.
this is under whose position now? Now this nephew and stepson.
No, it was in the possession of the deceased.
No, this is no more. Now with the, whether.
So after that,
No one.
the
Okay.
nephew tried to possess, but it was objected to by the other party. the respondent number one as well as the stepson.
Mhm.
So it was, there is another adopted son who was in the house and some tenants. But the respondent number one and the stepson who wants to be the successor, the heir, they were the ones who chased away the people on rent as well as the adopted son. But those were not brought into the notice of the Zongo court. But now status quo, they have their own share also. So what right do they have now to come and demolish the house? The position has already been distorted, Lordship. And given the unsettled position, I was begging your Lordship to initiate a suo motu contempt proceeding because right now it is not decided on who will be the legal heir. And RSA is still pending till the disposal of the RSA, Lordship. My Lord has seen that.
Now, according to you, the stepson is doing, or the opposite party?
The respondent number one and the
Stepson, who
they
is
have parted
the
ways.
applicant in the 48.
They have parted ways.
Ah.
When late Khutuli, the appellant, and the respondent number one, when they divorced, their property was also divided. And the stepson also, he went towards his father's side because he's the son of Viho, but not the son of late Khutuli.
Okay.
So they parted ways. Property was also divided. And since the respondent number one was trying to claim this property also, that is why the matter came before the Zongo court, which is pending now, Lordship, the RSA 1 of 2020. Now, in the meantime, when the status quo is still the disposal of the RSA, just because late Khutuli has passed away, the respondent number one and the stepson who also wants to be the legal heir, at the end of the day, Lordship, when the RSA is disposed, it doesn't matter whether the IA applicant of the IA 48 of 2023, whether if he becomes a legal heir, then at the end of the day, he inherits the property. But as of now, there is status quo order. So they have no right to come and demolish the house, Lordship. It is a contempt of court, my Lord. That is what I'm saying.
Lordship, the status quo speaks about possession of the house.
Now you see, it will be decided who will possess the property after that. So,
perhaps an unconditional
Now we will
apology will do. If not, I'm starting to get disturbed by my learned brother's continuous submission, which is highly unconstitutional, my Lord. He's my younger brother, Lordship, even outside the court, but this is highly unconstitutional, my Lord. Unqualified apology is what is to be submitted, not justify the action, Lordship.
Learning Council for the
Late appellant.
appellant, Mr.
Joshua Shakti, Lordship.
Joshua. And also, Mr. Opposite party, Learning Council for the respondent. You respondent number one, sole respondent. Okay, start. Learning Council for the appellant submits that during the pendency of the IA, during the pendency of, what is the number of the case which has been instituted in the district court?
Lordship, as far as the number in the district court is concerned, I do not know, my Lord.
Okay.
FA 23 of 2000.
Okay.
22 of 2013.
No, during the pendency, huh?
It's written FA 23 of 2013.
Okay, FA,
Huh? No,
'F' number, write that one. And write the name of the party also there. What, name of the party, kindly give the name of the party also there?
Yes.
FA, huh? What is the name of the, sorry, the number of the case?
FA 22 of 2013. The number.
In district court?
Yes.
Uh, Between party name? Whose name is,
It's Putoli and PVO.
okay, write the name of the party also, huh?
Because it's coming from that.
Registered. Pendency of the FA so and so before the learned principal district and session judge,
Dimapur.
Dimapur. Registered as per the direction of this court on 19/6/2023. As a resultant of the filing of IA Civil 28/2023 by the nephew of the applicant and IA, no, within bracket civil, bracket close 48/2023 filed by the son, stepson of,
Lordship is son, not stepson.
son
It's
of,
their claim that I'm stepson, but I'm the son.
son.
So
son of-
Lordship, as far as the biological relationship is concerned,
Hmm.
he is not the son, biological son of Khutuli. They don't have children. So he's a stepson. And that will be decided by the.
Whether
learned
it was
court below.
adopted son? No,
No, he's a biological son of
the father.
VO, the father,
Okay,
the respondent number
then
one.
it's stepson, I think.
As of now, any statement may go, Lordship, but
Lordship, please, but I have
Son.
it is their statement.
Son,
Yes.
It is my statement, Lord,
of the of the applicant.
but not a biological son. That is a proof, Lordship.
The respondent number one and the applicant in IA number, IA civil 48/2023 has violated the status quo order passed on 3/11/2021.
No.
Stop, huh? So it's, 2021 accordingly, suo moto contempt proceedings should be drawn against them. Stop. So what is your submission on this?
Lordship, I will instruct my client to maintain the status quo.
So what is your submission about the action that they have done, they have demolished?
Lordship, the demolition took place before they have filed for legal.
No, no,
So
no, the status quo order, it is still alive.
it has abated because the appellant has.
No, no, how it is abated?
Lordship, that with regard to the son, that the claim of the appellant in I-28, that the son was also involved. It's not true, Lordship. I was not involved in the demolition, Lordship.
Lordship, the final demolition took place only recently. They chased away the people on rent and the adopted son. They had an adopted son, Khotoli and late Khotoli and Viho. Their adopted son came towards the side of the mother and he was staying in her house. He was also chased away. And
Adopted son was also chased away.
Chased away,
By?
and the house has been demolished.
Now, by whom?
By the respondent and
Father.
but of course, that is a disputed question of facts and evidence since they are denying it.
Okay,
So I do not want to go strictly into that, but
okay.
it
then
is an act done by
only
the respondent number one.
acted by the respondent staff.
Respondent number one.
Now, how do we decide this then? Since you have already done, you have to pay for it. And probably the instruction was not properly given to you, the client, by an advocate. It's the duty of the advocate because the advocate knows what is law and the implication of the law, order passed by the High Court. And if it is admittedly, if it is done, then you see, you'll have to proceed. In case of decision in favor of anybody, you have to pay for it.
Lordship.
Okay. We're at this stage, the Land Council for the respondent submits that
Oh,
the act
my
of,
lord, my apologies, your lordship.
yes,
May I also take your lordship to the order dated 25 May 2023,
what is that?
25th May 2023.
Yes, what is that?
The last page. As the substitution petitions are still pending, none of the parties should take undue advantage of the death of the present appellant, and all the parties concerned here are directed to honor the status quo order issued by this court on 3/11/2021
Yes.
till the disposal of this appeal.
That's clear.
In spite of the death of the present appellant, but recently the entire house has been demolished.
Submit and undertake to compensate for the damage caused to the property
Let them file
in
by
question.
affidavit. We'll also reply to them. We'll also-
Property in question in case in case this case is decided in favor of the petitioner. Is it okay?
Yes, lordship. I'm just finding my learned brother's submission unfortunate. None of us are legal representative now. This for the honorable court to take cognizance, my lord.
The Land Council for the respondent also has undertaken that he will instruct his client not to do any further damage to the property in question till the decision of the case pending before the Land District Court, Dimapur.
No, the appeal here, lordship.
And
till the
the,
disposal.
and the present appeal. Okay.
My lord.
So stop. It is further submitted that the case before the district Court Dimapur could not proceed
My lord.
further due to the non-appearance of the witnesses.
Witnesses.
And prays for further time. Further time.
Yes, lordship.
It was granted for
kindly-
4 weeks, huh?
4
In
months.
fact, in fact, 4 months, lordship.
4
So
months.
another 1 month may kindly be
Okay.
granted to you.
And prays for further 1 month. Prays for extension of further 1 month. The para on the consent of the, sorry, in the same para, on the consent of the party, the prayer for extension of the further time, a further period of 1 month is granted. Put up this matter after 1 month. Okay.
My lord. Bless you, lord.
From the supplementary cost list for admission, item number 19.
Oh. Okay, 19,
Yes, my lord.
yes, please. Yes, please.
My lord, these proceedings are to be conducted in camera.
Oh, this is 19,
Yes, lordship.
bail also. Then
Yes, my lord.
I think this has to be taken up after all the matter is over, no?
My lord. Yes.
So let us take up some other matter. What else? We'll take up after and all matters are over. Okay, as the last item, will it be okay? As the last, item? Okay, please. Admission 5. Okay. Yes,
Your lordship,
Yes,
item number
your-
5 probably that,
so notice to be issued.
yes, your lordship. My lord, I have only implemented respondent performer respondent number 3, and otherwise everything remains same.
Okay,
Only implement as per the order of this honorable court. Because if I win the case, then the execution will be a problem if I do not implement.
okay.
And in earlier occasion, the state government has my learned college has accepted notice.
Mhm. This is recast petition.
Recast petition.
Okay. By this recast petition, the petitioner impeded the impeded
Performer respondent number.
performer respondent number 3.
Yes, your lordship. Deputy
The
Commissioner.
Deputy
Kumo
Commissioner Kohima, Nagaland is performer respondent. So, Land Council for the petitioner issue notice
Mhm.
upon the respondent.
My lord.
Anyone appearing?
Respondent number, performer respondent number 3.
Yes.
I'll set notice on his behalf.
Okay. Learned advocate, Mr.
Kiangabi.
Government advocate,
Yeah, Lordship.
accepted notice on behalf of the respondent, performer respondent number 3.
Lordship.
Okay. Stop.
I will submit the copy to him in course of the day.
Okay. The, since the learning council, Mr. So-and-so accepted notice on behalf of the performer respondent number 3, no formal notice need be issued. However, the petitioner shall furnish the extra requisite copy to him during the course of the day. Okay. List this matter along with the
Lordship, before 13 was listed, but since notice has to go, is on the way to Dimapur.
Okay. Okay, it'll
2
take
weeks,
time.
maybe,
Okay.
maybe less.
Okay.
So Lordship, instead of 13, why don't, if this is the Lordship on 20,
List this matter after 3 weeks.
After 3 weeks.
Okay.
Interim,
And interim
3/7/23, order dated 3/7.
interim order pass on 3/7/23. So, in the meantime, interim order pass on 3/7/23 shall remain, shall continue. Okay.
March of this.
Yes, yes.
For orders, item number 9.
Please, Lord. Lordship, I'm standing on behalf of BK Car. Lordship, here, the return service report is still awaited, and it's been a while by now. So kindly allow us to take fresh step.
You're for the,
Possibly.
this
Sorry?
is item number 9. You are
Yes.
for
And for appellant, Lordship.
appellant.
Yes.
Okay. Who is for the other side? Okay. So time required for what?
The return service report is still awaited, and then.
Okay.
You want to,
Service report upon whom?
the respondent number 2, Lordship.
Okay.
So kindly allow us
Learning counsel for the appellant,
to take fresh steps.
Mr. Swen, Mr.
Our semi, Lordship.
Simpson. Who submits that the step upon the respondent number 2,
Yes.
he is still awaited. Notice upon the respondent number 2 is still awaited and praise for. Grant, praise for 2 weeks.
So.
Hmm?
Allow us to take fresh step.
Oh, you want to take, okay, still awaited. You said it's still awaited?
Yes, it's still awaited, however. we
And
have-
praise for allowing him to take fresh steps
Yes, Lordship.
upon respondent number 2. Stop prayer allowed. The appellant shall take steps upon the respondent within 3 days.
3 days, Lordship.
3 days. Stop. Planet advocate, Mr. PP.
PP.
Okay, he is also present. Stop. List this matter after 3 weeks.
Lordship, may I kindly fix the date since the council is outstation, council.
Council is outstation. When you want?
Or date 23 of November, Lordship.
23.
Yes, sir.
Okay, list this matter as prayed for by the learning council for the appellant. List this matter on 23/11.
Much obliged.
For orders, item number 10.
Mr. Lordship,
Yes, please.
the complaint is order dated 3/10/23. I have served the notice upon respondent number 2 to trustee, and I have filed affidavit of completion of service report.
Which order is it? 2? 3?
Order dated 3/10/23, 3rd October,
What does it say?
3/10/23.
Notice about respondent number 2. Look, so have you taken step? Have you
Yes,
served?
Lord, on 11/10, I have served the notice.
Okay,
And I filed my affidavit on completion of the service report. But I've been after serving the notice to trustee, there's number 2.
they have received, duly received.
Yes, they received it. On my affidavit, I have annexed.
affidavit. Just a minute. Have you submitted an affidavit?
Yes, I filed yesterday, my lord.
I think it is not available. Is it available? No. Learning counsel for the petitioner, Mr. Okay. Parking Richapo.
Yes, my lord.
How do you pronounce it?
Pakin Ritapo.
Parking Richapo. Submits that he has taken the step upon respondent number 2 through justice service. However, despite of receipt of the service of notice, the respondent number two.
My lord,
is
my
not
humble prayer
present.
is that since respondent number 2 I've not represented, and since this bail application it has been pending for more than 5 months, and the accused is a heart patient, heart patient. So, my lord, if the court
And despite of
agrees,
service of
we can
notice
fix for
upon
hearing
respondent
after a
that
week.
The respondent number 2 remain absent. And since this is a bail application and needs urgent disposal, the matter may be taken up.
Lordship, in that view of the matter, let it come after 2 weeks, Lordship.
Okay, start.
Since, Lordship.
Also heard direct PP, Mr. Sunsu. So why this is the what is the offense against accused?
Offense,
Under what?
the alleged accused was arrested by the DRI on possession of heroin.
And
from
who is this
Dimapur.
respondent number 2?
Directorate of Revenue
Oh,
Intelligence.
director, okay.
So, this honorable court,
They are necessary party,
Lordship,
apart from the state.
Lordship, on the last occasion, this honorable court has directed to
Okay.
keep the TRI has a necessary.
Is
part.
there any advocate or standing counsel representing them? No.
Lordship, I'm told that they will be representing in this case, Lordship. However,
Okay.
so far they have not represented.
Inform so that on the next date, they also
Lordship,
represented.
Lordship.
It is prayed for by the Learning Council for the petitioner. List this matter after
a week.
After 2 weeks, Lordship.
2 weeks, after
Lordship.
2 weeks.
My lord, if since his bail matter and it's been pending since May.
How long he has been inside?
In fact, he have been arrested and prison for most.
What is the offense?
NDPS.
My maximum punishable, NDPS which section?
180 days, commercial quantity. But
commercial
it's only charge sheeted, my lord.
Not yet charge sheeted.
Yeah, it's
No,
only-
it is charged.
180 days over.
But
Yes, my lord,
before
it
the
is over.
mandatory period, charge sheet has already been filed.
Charge sheet not yet filed.
Filed.
It's filed.
Already filed.
Yes,
Within,
before 180
within
days.
time,
charge.
within time.
Lord.
Okay, within the statutory period.
Lordship, within the
Okay,
same.
then it's a regular bail.
It's only charge sheeted, my lord. Yes. And since it is charge sheeted, I am praying this
Okay,
bail
after
application
two-
may be
after two-
disposed the
after
earliest.
two- After 2 weeks, huh?
No.
Okay, I know.
For orders, item number 11.
Please, your lordship.
Yes, please.
My lord, this is an I application. My lord, there's a delay of 47 days. And then my lord, coming to the Limitation Act. I refer to, my lord. schedule
Delay
one-
in filing criminal revision.
Civil revision, my lord,
Oh, sorry, civil revision.
my lord.
Yes, please.
Since there was some error, I had to withdraw and then file afresh. But while, while to file afresh, there was a delay of 47 days. Now, my lord, I have paid under section 5 of the Limitation Act.
Yes.
Now coming to my lord, the limitation schedule 131. I refer to this merit.
to any court for the exercise of its powers of revision
Just a
under
minute, just a minute. Limitation.
limitation.
No. Okay.
Why not page 34, Limitation Act?
Yes.
Page 34, Schedule 131. 31.
Yes.
I read out. To any court for the exercise of its power of revision under the Civil Procedure Code, 1908. That is, period of limitation runs 90 days.
Yes.
The day from the decree or order. My lord, my case is in the order. I've withdrawn the civil revision and I'm filing for it. So in my testing application, there is a delay of 47 days, but I have never come across this came to light. So I'm referring to this. So the limitation period is 90 days. So there is ample time for me, and that the condone may be delayed. The delay may be condoned.
Delay of 47 days.
Yes, my lord.
Okay.
Yeah, under the business.
So,
yes.
What is this civil revision about?
My lord, is an irrigational canal matter that has been pending for. This canal was has been used by me for more than 50 years, but because of construction work going on, that the irrigational canal has to be diverted. So when I agitated before the village court was not in my favor. Then I approached to the DB's court. Then
what is DB's court?
That is the Dobashi's court. That is customary court.
Okay.
Yes. Then from the customary court, the order was in my favor. Then the opposite party, they want to go for an appeal. They appeal before the DB's court. There is another higher court. That is in the district court. So for that, I filed this this application.
No.
Civil revision. Yes.
So civil revision, you are challenging the decision of the
DB's court, my lord.
DB's.
My lord.
Full form is?
Dobashi's court.
Dobashi's.
My lord.
What is this Dobashi's court? Dobashi's court.
My lord, my lord.
And an appeal decision of the Dobashi's court.
Yes.
Where the appeal lies?
The appeal lies before the High Court.
High Court,
yes.
Right. Can you just show me?
My lord, I'm filing this application under section 115.
Okay.
115, read with 151, read with Rule 32 of the Rule for Administration of Justice and Police Act.
Okay. We'll continue at 2.
My lord.
So this Dobashi's court is under what? You have a book?
My lord, it's there in the library. Actually, I didn't bring.
Okay.
I thought it will be for the condonation.
Okay.
Yeah.
So the appeal lies before this court?
My lord.
Okay.
Rule for administration of justice. I know also not. It will be for the like okay.
Rule for administration of justice and police number, then all same.
Yeah.
Page number.
Page number 39.
Actually.
Yes. This is,
Yes, my lord.
yes.
My civil revision, as what I've stated, my civil revision was filed under section 115 and 151, read with Rule 32 of the Rules for Administration of Justice and Police in Nagaland. My lord.
Rules for Administration of Justice.
32, my lord, yes. Page 39, 32, new rule.
New rule 30.
Yes, my lord.
2.
I read out. The High Court or the Deputy Commissioner may, on an application by the aggrieved party, or otherwise call for the proceedings of any case decided by any officer subordinate to him and pass such order as may be deemed fit, provided that the aggrieved party may move such application only after availing of remedies by way of appeal, if any provided under the rule against such decision. So, basing on that, I filed my existing civil division 11-83. Yes. Now, my lord, coming back to my IE application 11.
Okay.
Yes, 111.
Delay of 47 days.
My lord.
So you have explained the delay.
Yes, my lord.
What
My
was
lord, here in my explanation, it's in para 4.
Para 4.
Yes, my lord.
Yes. 47 days.
Yes, 47 days.
Hmm.
And my lord, I'm referring to the schedule of the Limitation Act. That is on page 34, schedule 131, my lord. 131.
Yes.
Yes. Now, my lord, the time runs from, that is the day of the decree or order. My lord, in my case, it's order.
Okay.
So 90 days. So this application is filed within time.
So when the order was passed? 20?
Yeah, 26.
6.
23. Yes, my lord.
Okay.
So my prayer, my humble submission is that the limitation may be called on.
What is the reason for delay? Have you explained?
Pardon, my lord?
The reason for delay of
Yes, my
filing?
lord, I have stated that.
Where have you stated?
The cause of, yes, the cause is that the petitioner as well as the council, since we have a different schedule, we cannot meet. So that is the thing.
No,
But
where have you stated?
my lord is in para 4.
No, para 4 is 47-day delays.
Yes, my lord.
Where is the reason you have explained?
Yes. I read out that there was a delay of 47 days and the delay was caused due to the different schedule of the petitioner as well as the council to file the present civil division petition.
So that is the reason.
That was my reason given, my lord. But my lord.
Can that be the reason, only the sole reason?
Yes,
for,
my lord.
For condonation of delay?
Yes, my lord.
Delay need to be explained day to day.
Exactly,
delay.
exactly. But my lord, since this was notified to me, schedule 131. Schedule 131
yes,
is been known to me. So under the schedule 131, it is 90 days. So the 47 days covers within these 90 days.
Okay, within 90 days.
Yes, my
So
lord.
there is no delay then?
Yes, so
Just a minute. Order was passed on
26.
June,
my lord.
July,
Yes.
August, September.
Yes, my lord.
And when this was filed?
This was filed. This was filed on the
6/9.
yes.
Where is the delay then?
Actually, there was no delay, but I was not
7,
aware
8,
of
9.
this schedule.
So yes, you are for
And for the respondent,
respondent.
yes, your lordship, sole respondent.
Okay. So there is no delay.
Your lordship, but if my senior counsel has sufficient cause, I don't have any objection.
Okay. There is no delay because the order was passed on 26, 23,
Lordship.
June, okay? July, August, September 20. Till September 20, he has the time to file. There's 90 days, no? 90 days means up to 19 September. So this was filed on 6 September. Well on time.
Yes,
No delay. Actually, this should have not filed.
of course. I was not in the knowledge of this schedule 131.
Okay.
Yes, that's the only.
Okay, this is this is an application under section 5 of the Indian Limitation Act 1963, praying for condonation of delay of 47 days in filing the connected civil revision stuff. Hard learning counsel for the petitioner. And, Mr. Agree, Chusi. Agree, Zhao.
My lord.
Okay. This is item
11, my lord.
11. Oh, Elivil Zhao.
My lord.
Elivil Zhao. Land counsel for the petitioner and Miss
Teja Vitsu.
Nijabitsu for the respondent staff. At this stage, land counsel for the petitioner submits that in the instant case, the order this is the impugn order. Just a minute. Page 6 of your this application.
No, this was this thing. So I filed civil revision. That was this thing withdrawn.
No. When the order was passed, the order in that,
Yeah.
the impugn order, when the impugn order was passed, I thought this is impugn order.
No. My lord, the impugn order is on dated.
I thought this is impugn order.
No, my lord.
When the impugn order was passed, no. Just leave that, huh? This one not,
5/7/2022.
5/7/22.
22. Yes.
Now there will be delay, I think, then
No,
if it
my
is
lord,
2022.
Previously, I filed a civil revision. I've withdrawn that particular civil revision.
Earlier you filed civil revision.
Yes. And I have withdrawn that particular civil revision to file a fresh.
But then your limitation run. Limitation will not stop.
My lord.
Only because you have withdrawn.
Yes, see. On 26/23, I have withdrawn it.
Just a minute, huh?
Yeah, with the file a fresh.
Yes. Where is the impugn order page? Kindly sir.
Main petition.
Main petition page.
Page number 40. This is the translated copy.
Page 40.
My lord.
40.
My lord. This is the translated copy. In page 43, the order dated is given as 5/7/2022.
43.
My lord.
5/7.
My lord.
22.
Yes.
And then you filed this application.
I filed this application on 6/9/2023.
No, there is a delay, not only 47 days, no.
And
No, there is a delay.
My lord.
Because you, the impugn order was passed on 5/7/2022.
Exactly, my lord.
Then,
my lord, I have had a civil revision civil revision 11/2022.
There is a delay of more than 10 months.
No, my lord, you see. My lord, in my, this thing, I
11 months,
my annexure A.
Annexure A of?
My IA.
IA.
My lord.
What is this? This order, I thought this is impugn order, 26/2023.
Yes, this is the order where I have withdrawn the earlier civil revision.
Then, so.
Then I have prayed to the court.
Liberty was granted, but then.
Yes, to file afresh, my lord.
Yes, but then,
yes.
But you can't stop. The time once started, the delay, yeah? The limitation time once started means it will run. There is no order where it says whether this order, whether in the order has it reflected that the delay will or the limitation will not run. No. So no, then there is the delay. There is a delay of more than 11 months.
My lord,
I thought this is why you have annexed this? Should have annexed the impugn order, showing the date of passing order and then showing the delay. So here, this order, you have withdrawn the civil revision.
Yes, my lord.
So
I've withdrawn the.
This is only withdrawn.
Yes.
Yes. So not connected with the not connected with the running of the this time, no? The limitation. Limitation starts running from 6/7/2022. Then there is a delay of more than 10 months, 11 months. You have to specifically mention that this, and then even this also, if you want to mention this also, earlier you filed, and because of that, this much of time has consumed. You have to explain. This is not a sufficient is a cause to condone the delay. Only saying that due to different schedule of the petitioner, how do we? Do you think that this will satisfy the court and the other side? You have to explain the cause of the delay,
Yes,
day-to-day delay.
of course, of course.
Then, no, it can't be. Then people will start taking advantage. They will not worry about the delay of filing any appeal revision. You have to explain the delay.
My lord,
This,
my lord.
yes,
My lord, my civil revision 11 of 2022 was file meeting time. That was file meeting time. Being order,
explain this also. You explain this.
of course.
No, you have to explain. Otherwise, how do I write? How do we explain? You have to explain in your delay condonation petition that because of this, because of that, giving the reason that the delay has caused, and then day to day, and for that, that much of days has gone, and for that, 1 day, 2 day, 1 month, but then there is a delay of 11 months, more than I think 11 months, July, August, September, October. 90 days expire in October 4th and October. November, December, January, February, March, April, May, June, July, August, September, October. Now it is November. No. There is a delay of around 1 year. Around, no? You have to explain, and that this is defective because you have not explained properly. Date also not given properly. You only annex the High Court order where you have withdrawn.
Yes, my lord.
The revision. That cannot be the reason. No, I think you have to file additional affidavit.
My lord, in my.
And you are representing, or your senior will represent? You are representing.
My senior.
Your senior.
Yes, yes.
So no, you have to explain. Otherwise, how do we pass order? We have to explain. You have to satisfy the court that due to this, due to the reason, sufficient cause, you could not come before the court on time. Because you have not properly explained the date also is. And then delay, not only 47. It's not a 47 day.
My lord.
Whether the staff, the registry, whether used to check or not. That the delay of the day mentioned is correct or not, whether the registry used to check. The registry should check that the petitioner has mentioned 47. Registry has to count, and then a 47, what the petitioner has mentioned is correct. I have to say, actually, the registry. Registry has to say that and then recalculate and then give the exact delay, exact day of delay. If you have made a mistake, they should point out and ask you to correct it. So this is incorrect. I think you have to file a miscellaneous application, giving a proper date.
Okay,
delay, no? And then explain.
Okay.
And then saying that in the meantime, you file this revision petition on time. Why revision petition was withdrawn? And then due to that, you have asked for liberty, and then due to that, this much of delay has been caused.
Yes.
File it. Otherwise, I thought this is.
This application may be allowed. Then I may be able to file it fresh.
Okay. Third, Lanet Advocate Alivil Jao had Mr. Elibil Javlani counsel for the applicant. And also Miss So-and-so, land counsel for the sole respondent. Stop. Land counsel for the applicant submits that there is a mistake in calculating the delay in filing the connected revision.
My lord.
Revision, na? Civil revision. And praise for allowing him to correct. I think you have to explain the delay, day-to-day delay also, and probably you need to
My
correct.
lord, I'll do that in my application.
And praise for allowing him to file an amended petition.
My lord.
Okay, amended miscellaneous IA incorporating the exact day of delay in filing the connected revision petition. Stop. No? The prayer is allowed. The petitioner may file in the form of additional affidavit.
Amendment, I did. Amendment.
Amendment is allowed.
Amendment is allowed. The Honorable Court has.
You have any objection?
No, your lordship, no.
This was also filed. Okay, 9, this is 10, and 10, 11. Okay. Amended, again, your time, you will be.
My lord, 2 weeks.
It will, huh?
2 weeks.
No, if you file amended.
My lord.
If you withdraw, then your time again will run. Okay. The allow him to file appropriate application amending the delay in filing the connected appeal, connected revision. Stop. Prayer is allowed. List this matter again after
2 weeks.
2 weeks. Okay.
For orders, item number 12.
In IA 124 of 2023.
Yes, the IA for what?
This here this court by order dated 5/10/2023 as 5/10/2023.
Okay.
May I read?
Yes.
That Mr. Yangwadi, the next agency has filed this instant application, submitting that he has now filed the correct address of Westmoreland number 1 in terms of this court's order dated 4/9/2023, where it was noted that the notice of Westmoreland number 1 could not be served due to insufficient address. Considering the fact that the correct address has now been found, the course title of the civil revision 5/2023 is required to be changed and filed afresh. The learned counsel for the petitioner to take necessary steps this matter after 2 weeks. Lordship, due to some inadvertent mistake, I would not file the amended precast petition. So I pray that I may be given another 2 weeks to the course title.
Mr. Yangavat. Okay, Yangavat, learned CJC prays for 2 weeks more time to
file the recast
course title as per the direction of this court on 5/10/2023. Stop. Prayer. No one appears. Okay. Prayer allowed. List this matter after 2 weeks. Okay.
For hearing, item number 13.
Yes.
Worship, the instance civil review petition is filed against the,
This is for hearing.
yes, Lordship, is for
Hearing.
yes.
Okay, both are ready. All the party.
Yes. I am the sole respondent in this case.
Respondent.
Yes.
How many respond?
All the sole respondents.
Sole respondent.
Yes, Lordship.
First appeal. Yes.
Worship, the appellate hearing, the hearing are challenging the interim judgment dated 20/11/2018 passed by the Honorable Court of District and Circuit Judge Moore. Was in declaratory suit number 1 of 2023. Whereby the learned trial court, while passing the interim judgment and
Yes,
decree,
annexer, annexer.
and annexer is page 28. With the same interim judgment. Page 28, annexer 2.
Page.
Page 28. Page 28 is the judgment and page 45 is the degree.
28, oh, this is.
Page 45.
Two zero, not 20.
45.
No, 28.
Dated 20/11/2018.
No, judgment page number.
Judgment is page number 28.
28 is in the middle, issue number. Is it the same?
Worship, after the judgment, the lower court has also passed the decree.
No, page 28 is in the.
Is the civil suit judgment. Next page, Worship. Next page 29, judgment. Next page. The continuation page.
How it is 28, then 34. Oh, sorry, 27, 29. Let me just a minute, 28 is in the middle of the, I think, judgment, issue number
Judgment,
2.
yes, yes.
Huh?
Like one.
Okay, where it begins?
It begins from page 29. Page 29 begins from page 20. In fact, the order starts from 28, but the operative portion is from page 29.
No. Are we having the same, the first appeal?
No, the first appeal, this is civil revision.
Civil revision? FA number 3. You know the India versus? Which one?
Sorry, I'm sorry, my apology.
Okay.
Page 23. My apologies. I am
Page?
listening to other position.
Okay, page 23.
Yes. This is the interim judgment passed by the London District and Judge.
This is the impugn order.
My lord.
Civil suit passed by the court, district judge.
District Judge 1. District Judge 1. That is, date of judgment is 26/10/2028 and date of pronouncement is 20/11/2028.
Date of pronouncement is
2011, yes. And the degree is over 20/11/2018. 2011, that is page 39.
39.
Yes.
This is decree.
Yes, ma'am.
I haven't gone through, huh? So you have to
Yes, ma'am.
give the brief. Just a minute. Yes. What is the dispute about? Yes.
Worship, if I, worship may come to page number 3.
Page number?
Page 3.
Three.
That's the facts, page 3.
Okay.
Page number 3. Here, a brief facts of the case is stated here below. Para 4, Worship.
Para 4?
Yes.
Okay.
That the evidence beg to state that state will be the facts and circumstances leading to the filing of the declaration suit number 1 of 2023 by the plaintiff, and accordingly a written statement to the plaintiff by the appellant defendant hearing. 1. That in the year 1990, the then 13th Assam Rifle were stationed at Mon, and since at that point of time there was no adequate facilities and infrastructure to accommodate the 13 Assam Rifles, the petitioners had approached the state government to allocate adequate land for setting up their headquarters at Mon district.
Just a minute, huh? Yes. 1960. Petitioner had approached.
The petitioner, yeah, the present petitioner, they approached the state government to allot them.
And the present petitioner is Union.
The Union of India, yes.
Okay, petitioner approached.
The Union of India, they approached the state government.
Okay.
For allotment of land to establish state camp. That is 13 Assam.
Headquarter at, okay, Mon district, okay.
On the basis of the request, page 4, on the basis of the request of the Assam Rifle Authority, the state government approached the Konkan village for allotment of land to the Assam Rifles. That is present, the present Assam, where the Assam Rifles.
Okay.
2. The Konkan village agreed to give 50 acres of land to the Assam Rifles, and accordingly, an agreement dated 1911-1960 was duly entered into between the Konkan village, the state government, and the Assam Rifle for acquisition of 50 acres of land. Whereas the land under the occupation of the petitioners, Assam Rifle, was leased out to the Assam Rifle in the year 1960 and subsequently in the year 1978. By an agreement dated 27-10-1978 was executed between the Konkan village and the Assam Rifle in the presence of the district administration. The said lot of land under the occupation of the Assam Rifle measuring 50 acres was acquired by way of absolute purchase at a rate of ₹2,000 per acre, and in addition, a compensation of ₹1 lakh was also paid to the landowners, that is the Konkan village, by the Assam Rifles. So 50 acres of land was acquired by the state government, and that was allotted to the the Assam Rifles. Thereafter, in the year 1997, 78, the land was purchased by the Assam Rifle. Right? Agreement dated 27/10/1978.
78, 2710.
There is two agreements, Bashir. First was in 1960 and second was in 1978.
So the two agreement executed
Yes, Bashir.
between
Between the Kunga village, the Assam Rifle and the government authority.
village represented by
By the village chief, the Kambura, their head of the village,
head.
head of the village.
So they took this amount
Yes,
as a consideration.
for the land that is
Okay.
purchased by the Assam.
So these are, you have annexed. Let us see. Annexed 4 and 5,
Yes, Bashir.
please.
Page 40.
40.
40.
Yes. Okay.
May I read the agreement, Bashir?
Yes, please.
Land acquisition for construction of temporary headquarters of 13 Assam Rifle at Naginimora from Hongkong village. We, the Gamburas and the Ankh of Hongkong village, on behalf of the people of our village, do hereby come to an agreement to offer the land required for construction of temporary headquarters of the 13th Battalion Assam Rifles at Naginimora. The boundary of the area is as follows. 1. From the Nala near the inspection bungalow to the northeast of Naginimora Okchin Road up to 1 mile, that is 3rd mile post, including adjoining high features. 2. On the west of the said road, uncultivated area bounded by the footpath near the Nala running into up to 650 yards from 3rd mile stone. It's not very clear, Rashid.
So there is no type copy, no typed copy.
Sorry, Rashid.
Okay. How, supposing if we have to type it?
Then the following conditions are laid down.
No. This is to be quoted. How do we type? Maybe it's not legible. Okay, then could you read this? 450 yards from. If this agreement is to be quoted in the judgment, we need to type.
Yes, Lordship.
And unless this is clear, how do we? Could you read? No.
After the matter is heard, Lordship, I can produce that copy. If the Lordship please.
Okay. Please. No, in the down below also. Plant is. Please, go ahead. But it's not legible. Please. And what about the other copies?
The second agreement is page 41. Page 41. And it's
Just a minute. Here, this signature.
Yes.
Is SD. No signature.
Which one was it?
No, page 40.
Page 40. Yes, Lordship.
There is SD.
No, Lordship, it's a left thumb version of.
And then LTI.
On the right, on the right side. LTI of so and so, LTI of so and so.
But is this the photocopy of the original?
Yes, this is the photocopy.
No, then there is no signature. If it is a photocopy, no LTI.
Otherwise, Your Lordship, I call the original reports.
Do you have the original? Respondent.
No, he's the petitioner, the
I'm the
petitioner.
respondent in this case, Lordship.
How many respondent?
Only one. I am the sole respondent in this case, Lordship.
Okay.
Lordship, my humble submission.
Ah.
The actual fact is not properly explaining before your Lordship now. The fact is that there is no dispute in regards to the allotment of 50 acres of land to the Assam Rifle Authority. There is no dispute. And even these two agreement, if it is not considered by this court also, there is also no dispute, because in the entire proceeding, the dispute only is regards to the 26.42 acres of land which has been illegally encroached by the appellant in other than 50 acres of land. The dispute is only regards to the 26.
Okay, not the 50, not the 50.
Yes, Lordship.
The civil suit will not be tried properly because the state government has not been made a party. We have filed an application for making the state party respondent, because the allotment was given by the state government. Survey was done by the state government, but the state government was not.
Allotment was given to whom?
To the Assam Rifle, the Union of India.
After this agreement?
No, in 1960, we have approached this, the Assam Rifle has approached the state government to give us a land to establish our camp. And as such, the state government, they approached the Kungan village. And the Kungan village, on the assurance of the state government, they have given the land to the Assam Rifle. And the survey was also conducted by the state government. But in the civil suit, the state respondent has not been made a party respondent. The Assam Rifle has also filed an application for impeachment of the state government in the civil suit, but my application was also rejected. That is why the suit could not be tried properly.
No,
the absence of the state government.
So this is regarding 50 acre.
Well,
50 acre.
Yes, and we are alleging that the respondent that live here is established a canteen inside that 50 acres of land. Within that 50 acres.
Within 50 acres. Now, what is the total land you are possessing now?
50
Assam
plus,
Rifle?
50 was 126. 50 plus 126.
50 plus? 50 acre plus?
Plus 26.42.
26.42.
Yes.
So this, with regards to the 50 acre, there is an agreement between the party, village.
There is an agreement, yes.
These two, in the first agreement, how much of land? In the first agreement?
Lordship, what I want to say is that, the canteen, where the plaintiff has placed, is within the 50 acres of land. The 50 acres of land which was acquired.
No, let us be clear. Let us be clear, because you said that as per this agreement, 50 acres.
Yes.
Were given to you on the strength of this agreement.
No.
And this agreement was entered between you and the
villagers.
Villagers.
The villagers, the district administration, and the Assam Rifles.
And Assam Rifle. Yes. Then this agreement won. Under agreement won how much? 1960?
1960.
One is 78.
One is 78.
In 1960, how much of land?
Lordship, in the first agreement, it's very vague. The first agreement was very vague. So that is why they have entered into again the second agreement.
But second agreement, how much of land?
50 acres of land. That's
Where do we find 50
page
acres of
41,
land?
Page 41, Lordship. Page 41.
Okay,
Second para, the agreement covers the following.
50 acres of
50
land.
acres of land as
Okay,
follows.
so that is only 50 acres.
Yes.
That is acquired from the village
Yes.
by paying this amount.
Yes.
This is a compensation, okay. Compensation of this much. So now now you are possessing 50 plus 26.
Yes.
That means 76 acre.
Yeah.
So where does this 26 acre come
Because
from?
the land was taken over without survey, and we have occupied the land. And after occupation of the land, survey was conducted, and it was found that some excess land were under the occupation after Assam Rifle. So in order to adjudicate the matter, the state should be made a necessary party. And without the state, this matter cannot be adjudicated.
No, there are after this,
Because
after
the
this.
land was allotted by the state government, and survey was allotted by the state government.
This is what you have annexed is, this is agreement.
Well,
Subsequently, whether you have been allotted by the government,
no,
who measured then this land? Who measured this land? That it is not 50, but it is a 76 acre. Who measured the land?
the land record office.
Hmm?
Land record office,
Land record office.
yes. Survey.
Whether the land records office after measurement, whether given you as allotment in the form of allotment. They gave you only measurement. Where do we find that measurement? Where do we find?
Lordship, after the survey report, there was some negotiation was taken up between the
What was taken up?
negotiation between the Assam Rifle and the
Now,
villagers.
where do we find that 76 acre of land, the figure? 76 acre of land measured by the government, where do we find here?
It's not included in the it's not included in the survey report is not.
Then on what basis you are claiming?
That is why what I am saying is all the reports are with the state government. We do not have the report with us. The report is with the state government.
But then as per the agreement,
so the survey report could not be produced, the map could not be produced.
but as per
I
the
don't have
agreement,
a copy
only
here.
50.
All the copies are with the state government, Lordship.
State government.
Yes.
Okay, who filed this title suit before
Civil
the?
suit brought by the plaintiff, the respondent hearing.
Okay, so civil suit filed for how much of land?
Lordship, the actual fact is not placed before your lordship.
Okay, what is the actual fact?
Yes, actual fact is lordship.
Just a minute. Huh?
Yes,
I just
lordship.
wanted to clear
Yes,
before proceeding, huh?
I have prepared a small gist, may I provide one copy for your
Please,
lordship?
Because unless we are clear,
Yes.
we can't proceed further.
Certainly, lordship. Lordship, the fact of the case is that the present respondent plaintiff in the appeal belongs to a Naga community of Koinak tribes who's having their own customs and traditions in regards to the administration of justice as well as administration of land and property within the jurisdiction of the respective village and clan or within the jurisdiction of respective village council lordship.
Yes.
The custom uses and such practices are well acceptable among the Naga society at large in the state of Nagaland as well as even in the court of law. Lordship, prior to 1974, Kangan village and its villagers, including the plaintiff.
Do you have the extra copy? Can you serve a copy to the land council for the petitioner also?
Copy is not required to be served. Otherwise, I'm reading it.
That's fine. So that, for clarification.
Yeah. If he have any objection, he may raise.
Please.
Yeah. Plaintiff father late Henze Koinak were occupying a large portion of land as per their traditional custom, practice, and uses prevailing among the Koinak community, and thereby become the absolute owner of land. The appellant hearing in the year 1960 approached the Kongon Village Authority through the government of Nagaland for allocation of 50 acres of land for construction of temporary headquarters of 13 Assam Rifle Battalion at Naginimura, Nagaland. Considering the prayer, the Kongon Village Authority on behalf of their village executed, signed and delivered one lease agreement as per their traditional customs and practices prevailing at the time with the appellant on 19/11/16.
It was a lease agreement.
Yes, Lordship.
Okay.
It was a lease agreement. Exhibit P2. Though the said agreement, only 50 acres of land was given to the appellant Assam Rifles with a restrictive condition number 2 that no further requisition of land on the west side of the road will be accepted by us in future. That is the.
It is in the agreement.
Yes, Lordship. It is in the agreement. Exhibit P2, Lordship, in my LCR record.
LCR.
Yes, Lordship. LCR is there.
Where do we find LCR? P2 is the same document with the annexure, I think is.
Exhibit P2 is the agreement executed and signed and delivered on 19/11/60.
Nine.
19/11/60.
Just a minute. 19/11/60. This document, I think, is the same. No.
Same, Lordship.
No, where is LCR? LCR we have. Have we received the LCR? No. Then? LCR not yet received. How it has come to the hearing?
Then it cannot be heard, Lordship.
Hmm?
If the LCR is not here, it cannot.
LCR is necessary.
Can we verify it may be misplaced somewhere also?
I think LCR, whether called for or not. LCR also not called for. I think we need to call for a LCR.
Yes, Lordship.
How can we proceed?
LCR will be called for, Lordship.
How it came to, how it has been listed in the hearing in the column? Anyway.
Actually, this matter should not be listed for hearing.
Hearing should have been
In advance of the court. Yes, LCR.
Vote the learning council for the appellant. Mr. Where is that? Please go. both the learned counsel for the appellant, Mr. Mayawati, and
B N Sharma.
Ian Sharma for the respondent are present. So, after hearing for some time, it was pointed out by both the learned counsel for the parties that else in the instant case, LCR is required. However, it has not yet been called for. So, in view of the above, let the LCR be called for. How much time it takes?
Most probably 2 to 3 weeks period of time.
3 weeks. Mon is 3 weeks. No? No problem.
Upon receipt of LCR, maybe matter will be fixed.
This is matter after receipt of the LCR.
In the order column.
In the order column, so that we fix on for hearing. Okay. This is matter after. Okay, after receipt of the LCR in the order column. Huh? Okay.
So, may I request your lordship to?
Yes, please. Please, hand it back to him. Yes, please.
For hearing, item number 14.
May it please your lordship.
Yes, please.
Lordship, the instant appeal is filed under section 173 of the Motor Vehicle Act, your lordship. I can see impugn judgment and order dated 22/10/2019, your lordship.
This is for hearing.
Yes, your lordship.
Okay. You are ready?
Yes, your lordship.
Whether the LCR was called for here in this
Already
case?
also. Yes, your lordship, LCR was called.
LCR is ready? And who is for the other side?
I'm for the respondent claimant.
For the respondent.
Yes.
Lordship, there are two responses, your lordship here.
Two respondent.
Yes, your lordship. For respondent number 1, the council is appearing. For respondent number 2, your lordship, notice have been completed, your lordship. Or by order.
You are for respondent number 1,
Yes,
Mr.
Yes, lordship.
1.
Yes.
And
And
for
for
respondent
2,
number 1, lordship.
Lordship, notice have already been completed, your lordship.
completed means they have received.
Yes, your lordship.
They are not, are they not? They are
Lordship-
not contesting.
If your lordship would come to order dated 19/17/2010 to your lordship.
19?
7/2010 to your lordship.
2022?
22, your lordship. Yes, your lordship. Lordship, on that particular day, your lordship, notice that notice was issued to the respondent number 2 through newspaper publication, your lordship.
No, just
And today the fact
22,
affidavit was filed, your lordship.
Not 23, 22.
22, your lordship, 19/7. 19/7, your lordship. 22, your lordship.
Just a minute, huh? Not even 19/7/2022.
22, your lordship. Yes, your
It's
lordship.
not there. Where is the order sheet? Rest of the order sheet there? No, it starts from 14/11 only. This is miscase. I have given miscase. This is miscase. What is this miscase about then?
Lordship,
MSC appeal, but then
and it will, your lordship.
not miscase, just a minute, huh? But this starts from when
Lordship, this
did you
matter
file?
has been filed on 2022, your lordship.
22,
2020, your lordship.
20.
Yes, your-
Where are those orders, order sheet? It starts from 14/11 only. 14/11/22. The sheet is start from 14/11 only. Then comes 23. Somewhere misplaced. It says,
2020, Your Lordship. The instant appeal was filed on 5/6/2020, Your Lordship.
you are referring to order
1917.
19/7, 2022. It's
Yes,
not
Your
there. It's not there. Abstain. It's not there. Can you just show me the order which you are having? Do you have the copy?
No, Your Lordship, I don't have a copy, Your Lordship.
Then
Lordship,
what the order says? That order?
Lordship. Lordship, if I may be allowed to read out, Your Lordship. Lordship. The applicant was permitted to take steps for service of notice upon response number 2 in substituted manner by publication of the notice in local daily newspaper having wide circulation in and around the area where the response number 2 is said to reside. In difference to the order dated 26/04/2022, the application/appellant has taken steps to publish notice in the English daily newspaper, the Sentinel, in its issue 21/05/2022. Notifying that the next date for listing of the case would be 26/05/2020. The applicant/applicant with regard to the manner of application of the notice is substituted mode has filed an affidavit. None has appeared for response number 2 after publication of the notice. Having gone through the apartment met in the compliance affidavit and the contents of the notice published in the daily newspaper, the Sentinel, it is issued 21/05/2022, the service upon response number 2 is held to be complete.
Okay.
As sought by the learned counsel, the matter was listed in your.
Respondent number 2.
Yes,
So
Your
he is, who is he? Owner or?
Owner and the driver, Your Lordship, of the.
Owner and driver.
Yes, Your Lordship.
And then, you are representing whom?
The occupant, Your
I'm for
Lordship.
the respondent claimant.
Who is insurance?
No,
Your Lordship.
I'm for the claimant, Lordship. He is for the insurance.
I am for
Oh, you are for the insurance.
Yes, Your
insurance. You are for the claimant.
I am for the claimant, Lordship.
Okay.
Lordship.
So it was directed to pay to whom?
To the
Who
insurance
is
company.
liable to pay?
Directed
Insurance.
to the insurance company to pay the awarded amount of rupees 9,80,065 rupees.
Yes, Your Lord.
Okay.
Along with accrued interest 9% from the date of filing of the claim petition, the deposit of the amount.
Okay.
So being agreed with
Then
the
it was,
amount,
direction is to you only.
Yes, Your
If
Lordship.
you are liable. So that means we can go, but then where is the record? We can go ahead otherwise, but then where is the record? Record is not available. LC. So anyway, so you have filed affidavit. Mr. What is your good name? The respondent, have you filed affidavit?
no, Lordship, that part is already over because there is a condonation of delay. Delay has been condoned by this honorable court.
Okay.
And thereafter, being satisfied with the service of notice and others, delay has been condoned.
Okay.
And now the matter is placed before your Lordship for hearing. So we do not know whether LCR is here or not.
LCR was called for, huh?
Yes, Your Lordship. LCR was called.
LCR. So, you have deposited 50%.
Yes, Your Lordship.
That has been allowed
Yes,
to
Your
withdraw also.
Okay.
That has been allowed to withdraw.
Allowed to withdraw.
Yes,
So
50% of the ordered amount.
before disposal.
Before disposal. yes,
Before
Lordship.
disposal, Your
That is the
50%
procedure
is
of law.
okay.
Yes.
50% is allowed.
Yes, Your Lordship.
Okay. So you are not filing any. Okay. Receive. Receive, no? It's available. Okay. So I think there is some problem. So, tomorrow is hearing day.
Tomorrow is a DB, Lord.
DB, Your Lordship.
DB.
Thursday, Your Lordship.
Maybe hard on Thursday.
Next Thursday.
This Thursday, Your Lordship.
Oh, this Thursday? Okay. You are available. You are,
Thursday means it is a second.
you are based here only?
No, I used to come from Lakhimpur, Lordship.
Lakhimpur. When do you want?
So
This
now
week
I'm
or next
here.
week, huh?
If your Lordship feel it convenient, it may be fixed on 2nd of November.
2nd.
November, 2nd.
Oh, 2nd November. Second is Thursday.
Thursday, Lordship. It's a very small matter,
Okay,
Lordship.
we can fix on Thursday.
Yes, Your Lordship. At
Okay.
9, Your Lordship.
Both the land council for the applicant and respondent are present. And praise for fixing the matter on Thursday.
Lordship.
Lordship.
Okay. Okay, Thursday. The prayer granted. List the matter on Thursday for hearing.
Yes.
Thursday means in the 2nd
Second.
November, Lordship.
The 2nd November.
Yes, Lordship.
March.
2nd November for hearing. Huh? Okay.
For unlisted motion, bail application 23 of 2023.
Okay. Yes.
My lord. File application under section 439 of CRPC.
439.
Yes, my lord.
What is the offense?
The offense is related to kidnapping for ransom. And this is mentioned in the file.
Oh, just a minute. Huh?
Yes,
Let us see.
if you would refer to page number, if my lordship would refer to page number 9 of my application, you will find page number 9 of my application, you will find the basic.
Page number 9.
Yes.
What is that?
The offense in which the accused have been
Okay.
arrested. So
Kidnapping for ransom.
yes, section 364A IPC, kidnapping for ransom, punishable with death or imprisonment for life and shall be liable to fine. Section 384 IPC, extortion. And section 324 wrongful confinement. Section 323 IPC, voluntarily causing hurt. And section 34 criminal act done by.
Okay, let us see the FIR. Let us see the FIR.
Yes, now the FIR is in page number 20.
20?
Yes, my lord. FIR is in page number 20. If you would kindly-
20. Oh.
Yes. My humble submission before my honorable lordship. The FIR has been filed on a frivolous ground by the informant of
Okay,
the.
okay, let us read. Let us just read.
Yes, let us analyze the.
Mm.
Yes. In this case, 9 persons have been arrested, my lord. 9 persons have been arrested, in which I am filing for bail of bail of the present 4 applicants in this petition, my lord. So, as we will analyze the this FIR, my lord.
Yes.
Mr. Dilbar Hussain is the informant of the FIR. A regional taxi driver would like to step up on that 2/10/2023 in the evening. While I was waiting for passengers at Dimapur taxi parking railway station area, along with my brother who drives my other taxi vehicle, namely Anwar Hussain. Anwar Hussain is the victim here. Later around 8 p.m., I saw one person, namely Amir Uddin. Amir Uddin is the accused number one in this offense, who came to my brother Anwar Hussain. Anwar Hussain is the victim, and took him near one private vehicle, Tata Punch. After which two local Naga person came out of the vehicle and put Anwar Hussain inside the vehicle forcefully and fled away. After some minutes, two local Naga people came in scooty, and one person took away my taxi vehicle bearing NL01T9891 Alto Standard. Later around 8:30, one unknown person called me up in my mobile from Anwar Hussain mobile and asked me whether Anwar was my brother or not, to which I replied that Anwar was my brother. Then the unknown person demanded 10 lakhs from me for release of my brother, or else they will kill my brother. And out of fear, I told the unknown person that I will pay rupees 20,000 from my mobile, and the rest of the amount I will come and hand over to him. I paid rupees 20,000 in Amir Uddin phone pay number and went to his police station to report the incident, my lord. Now, if you will come to the next page, which is the first information report, the filing report of the police. Herein, we can see that the number 3 is the occurrence of offense day, Monday, on Sec 2/10/23, time period 7, time from 18 hours to 21 hours, which means the offense has occurred around 6 to, on that 2, the offense has occurred around 6 to 9 p.m. in the evening on 2nd. Information for FIR has been received on 3/10/2023 around 1 p.m. General diary reference is on entry number 3/10/2023, time 9 hours.
Okay, how many of how many was arrested in connection with
Herein,
the case?
9 persons were arrested, and the informant of the FIR is believed to be an illegal drug seller, illegal drug vendor. Now, as we can see from the analysis of the kidnap of the FIR, Mr. Dilbar Hussain, who is the informant of the FIR, already knew the person who is accused number 1, Anwar Hussain. He is mentioning here, I was waiting for passengers at Dimapur taxi parking railway station.
Where are you reading from?
Yes. So, if you will come to page number, my lord, if you come to page number 26 of my petition.
Yes.
My lord.
Yes.
Here, this is the accused forwarding by the IO of the guest
Yes.
at present. So, herein, if you come to the next page, there are 11 persons that have been arrested. 3 people are non-local. They belong to Muslim community. The informant of the FIR is also Muslim community. They are having a constant money transfer between them. In fact, the informant of the FIR was having some debt to give to to this accused person, Amir Uddin. So Amir Uddin and 2 other friends of his community, they informed some acquaintances A4 and A, accused 4 and accused 9 in this page, in this forwarding report, my lord. So accused 4 and accused 9, they are associated with accused number 1, Amir Uddin. Now I am filing up the present, in my present application. I am filing for the bail. I am filing for bail of accused number 1, accused number 2, accused. My lord, just one moment. I am filing for the bail of accused number 2, accused number 3, accused number 5, and accused number 6. These are 4 persons that were not involved in the crime, my lord. They were sitting at a particular place in the stadium right after their board. They are engaged in a daily labor. They are engaged in daily wage laborers. So after their day's work, they went to a particular place called Dimapur Stadium. From there they were having some intoxicating drinks like alcohol. And when they were about to leave, accused number 4 and accused number 9. Accused number 4 and accused number 9, who are acquainted to them, they informed these persons to come and accompany them to recovery of some money from some non-local person because they have some dues to get from this informant of the FIR. So, in fact, accused number 4 and accused number 9, they are related to accused number 1, 7, and 8. They are having a constant touch with them, and because of this, the present accused number 2, accused 3, accused 5, the present applicants, they are honest and they are honest person, my lord, as per my submission. And even in the statement 161, even in 161 CRPC statement of the accused persons also, they have specifically mentioned, it seems, which I have collected information from the jail. So they have specifically mentioned that these 4 present accused, they are not involved in the crime at all, my lord. They were sitting in the stadium, they were being misled into committing this offense, in fact, my lord. So
all of them were remanded.
So
now they are under judicial custody.
They are under judicial custody. 5
okay,
days.
then what happened then?
5 days they were in police custody. So on
5 days they were under police custody.
Yes,
okay.
on 3rd October they were arrested. Till 8th October they were in police custody.
Okay.
On 8th they were remanded to judicial custody.
What is this? What is this annexure for?
Annexure 4 is the this is a bail application that has been filed earlier in the Sessions Court at Dimapur.
Okay, on
yes.
behalf of?
Yes, and then the annexure
No,
4,
this was filed on behalf of how many accused?
On behalf of the present 4 accused only, my lord.
4 accused
Yes,
persons.
the present 4 accused pending before.
So this was rejected or
the application has been rejected without giving any observation. What my opinion is, if the prosecution, if the police wants to keep me in jail, incarcerated, involving my right to freedom of liberty, right to life, and my right to freedom, then they should produce a reliable information through, since IO has been given enough time to.
When this was rejected?
The bail was rejected on 16, my lord, 16 October 2023.
16.
Yes.
So what was the ground you have taken in that court?
The grounds I have taken is on this in fact one of the applicants here is suffering from stage 4 appendix due to burst anytime.
Whether that ground was also taken?
The ground was also taken. So
okay.
Yes,
so, but the court, trial court rejected.
The trial court has given in the last paragraph of the
last
at page 32.
No,
I mean like the trial court has said that at this stage, appendix is not a serious illness.
Okay.
Therefore, at this stage, bail may not be granted. That is what that is the observation
and then,
of the sessions judge.
On that ground, your bail was rejected. And what is the new ground that you have taken this time?
My lord, my new grounds are I have received a lot of more. I have collected more information from the people who are in the prison. Because earlier I could not collect much information because they were in the IO, they were in the custody of the police. So I filed the application on 9th of October. So 9th of October I was not given enough time to collect more information. So on the basis of whatever information I had in my disposal, I filed for the this bail application, my lord. And
what is the information you gathered? New information you have gathered?
I've gathered more information that even in 161 statement of even in section 161 statement of all the accused, they have confessed, they have given the statement that they are
accused, including you, the 4.
Yes, including me. The
okay, then what remains? If you have admitted the guilt,
my lord,
confessed.
Yes, they have said that I have been misled into committing the offense. Otherwise, I cannot be part of section 34.
Then there is a prima facie case. You are involved.
My lord, prima facie case. I may be involved, but I was misled into collecting some kind of debt money to help my elder people because I am age 24, my lord.
Now,
those people are age 45. I've been misled because they're elders in my same locality. So it is a brotherhood feeling among Naga. In Naga community, there is a feeling of brotherhood. Today you come to my help, tomorrow I'll come to your help. Such kind of incidents occur every time, my lord. And then the present four accused, in consideration for bail before my lordship.
The matter is still under investigation?
Matter is still under investigation, my lord.
Charge is not yet filed?
Charge is not yet filed. My lord,
But
what
for consideration,
what I want to press before my lord is, if the police wants to keep me under the custody, or if the police wants to keep me under the custody, then in the pretext of investigation, I should not be allowed to suffer under should not be allowed to suffer incarceration. That is my, without bringing out any proof, whether through electronic forms, whether through material proof or whatever. If they don't have any proof, based on this simple FIR, I cannot be allowed to be incarcerated. Which questions, which challenges my right to life, my right to freedom, right to liberty, my lord, which is even in this. I have taken one reference of the Supreme Court latest judgment, my lord, in page number 11 of my petition, my lord, before your humble consideration. In page number 11 of my application, my lord.
Okay, what is that?
Yes. This is the guidelines given for bail by the Supreme Court in one of its latest judgment, my lord. This is the for the sake of brevity, I will just read whatever is available on the petition, my lord.
Okay.
Yes. That reference may be placed in the case of Satendra Kumar Antil versus the Central Bureau of Investigation, SLP 5191 of 2021. This matter concluded in 2023 March only, my lord.
Yes.
The Honorable Supreme Court has issued guidelines on the grant of bail to an accused, and while doing so, it has reiterated that aspects of personal liberty and constitutional guarantees available to an accused, and has issued directions to all high courts to be liberal while granting bail. To be liberal in their approach and not to pass detention order in a routine and mechanical way. Further, in para 11 of the aforementioned judgment, it is observed. The principle that bail is the rule and jail is an exception has been well recognized through the repetitive pronouncement of the Supreme Court. This again is the touchstone of Article 21 of the Constitution of India. Coming to the next para, in para 19. In Re Nachendra Nath Chakraviti, 1923 Supreme Court on line 318, that the bail is to secure the attendance of the accused at trial. The proper test is to be applied in the solution of the question whether bail should be granted or refused is whether it is probable that the party will appear to take his trial, and that it is indisputable that bail is not to be withheld as a punishment. At this stage, without taking me into trial, I cannot be allowed to suffer incarceration, which involves my right to life, my lord. That is my humble submission before you, my lord. So we are a group, the present applicants are a group of 4 people. We are placed in the lower strata BPL community from the society. And A1 is already married. A1 is age 24. He is already married and has 1 children. He is a daily wage laborer. And A2, which I have mentioned in my page 5, para 7, my lord, please.
Okay.
Page 5, para 7, just for just to assist my lordship. In page para 7, page 5, I have written that A2 is married for the past 4 years. Wife is presently pregnant and is a daily wage laborer. He is unemployed. A3, unmarried and have health complications. He is a daily wage laborer, my lord. This A5, married for the past 5 years, having 1 child and wife pregnant, a daily wage laborer, unemployed. Alkampa, unmarried and arranging for engagement and marriage this year, my lord. Just two months are left for his marriage and engagement. All these are like basic conditions, basic circumstances of the present accused, my lord. So
okay, to appreciate, I think we need to call for the case diary.
My lord.
Produce case diary, how much time it will take?
2 weeks.
2 weeks.
Dimapur, this is how this is that possible in 2 days, 2 weeks, Lordship.
My lord, 2 weeks will be, again, my lord, 2 weeks, it is about that time, my brother may kindly reconsider this.
Learning Council for the petitioner, Mr.
May it be listed on Monday, my lord.
No, Lordship, that is not possible. Dimapur is coming up from Dimapur, Lordship.
Let us ensure that it is listed along with the CD.
My lord.
Okay. Learning Council for the petitioner, Mr. You are,
And Supreme Lord, it is in the petition, my lord. And is that Mukhtar,
okay. Mother.
on the front page of the petition. And that
Learning
Mukhtar.
Council for the petitioners, staff. This is an application under section 439 of the Code of Criminal Procedure, 1973. Praying for grant of bail to 4 accused persons, namely Ilithung Mozui. 2.
Accused number 2.
Maware Sangtam.
Accused number 5.
Lichanthong Obong.
Accused 3.
Aukumba and Aukumba.
Yes, accused 6.
Who have been arrested in connection with the Dimapur East PS case number 247/2023 under section 364A/382/323/34 IPC. Stop. Also heard Learned Council for Learned PP. Mr. Swenson, Mr. Swenson, Learned PP, Nagaland. Okay, stop. Call for the case diary. The Learned PP shall produce case diary.
My
Lordship, practically not possible, at least 2 weeks.
2 weeks now, okay.
Lordship, in view of the order passed by the Honorable Court, Supreme Court in Asian Road Servicing Private Limited.
Let us ensure 2 weeks.
Yes.
Okay. List this matter after 2 weeks along with the CD.
Lordship.
Case diary. Okay. For bail hearing. Okay.
My lord, I have to travel from Gauhati, in fact. So
When you want the matter to be fixed?
Since I live and practice in Gauhati, I could have to travel. So should we make it a fixed date, my lord?
Okay, when do you want then?
2 weeks, make it on 10th of November. Friday, 10th of November, Friday.
It's not 2 weeks, Lordship.
10th, I think is holiday. 10th is holiday.
That's holiday, yes.
Then
It's
it
the
will
one.
be-
Make
it will
it
be-
9, my lord.
It will be 13. 13, Monday will
My
be.
lord, 13, 14, 15, I have a bail matter at UPR in Itanagar. So 13, 14, 15, it won't be possible. So my lord, for the crowd, for the, make it on 9, my lord.
9th, is it
My
possible?
lord,
If CD has not come,
I will request yeah.
Today is only 31.
Today is
I think
31.
almost two weeks you get.
Yes, 9 is more or less.
9th, is it okay?
okay.
Okay, 9th,
Yes.
Okay.
But
okay,
the thing
9th,
is,
make it-
it's very difficult to guarantee it that for sure we will do the date.
He is taking risk.
Otherwise, if you want to take chance.
Information will be given.
Okay.
Lordship, if it can be sent in the form of a scanned CD.
Okay, I'll call for a scan CD then.
Yes.
Scan CD. That is possible, I think. Okay.
Much obliged, my lord.
For admission, item number 19.
Nineteen also, Oh, then I think this is in camera. Then this also is to be put up. Okay, so all are requested because this is in camera trial. Rest of the advocates are requested kindly to assist. You are also connected with this case? Okay. in camera, this also, this also,
Yes.
they are good. Okay, they are on the way. Please. Is it okay? The camera is,
Yes, Lordship, it's okay. It's okay.
is it okay?
Yeah.
Okay, please.
Lordship, on the previous occasion also, we've made our submissions. And